Okay, we're going to get underway here. Good afternoon and welcome to the July the 29th convening of the Baltimore City Board of Municipal and Zoning Appeals. Before we get underway, a few housekeeping matters. First, if you have a cell phone or anything else that makes any kind of audible electronic sound, anything that rings, chimes, beeps, plays a tune, we ask that at a minimum you please turn that to a vibrate only, if not off position. The reason for that is pretty straightforward. You note that there are a number of microphones which are arrayed around us up here, and those microphones are all very sensitive. They're for the purpose of not just amplification, but also for the purpose of recording these proceedings. Additionally, you'll note that behind me there are 2 video cameras on the wall, and those of you who are forward of the wall there can see that there are 3 cameras behind you. These proceedings are being recorded for broadcast, and cell phones, pagers, anything making noises from the gallery disrupts the general conduct of the proceedings as well as the recording of the proceedings. Additionally, to the extent that you find it necessary to have a conversation with someone who's sitting next to you or someone who may be a little bit further than right next to you, we ask that you please take that conversation out the double doors to your rear for the same reason. We will be voting at the end of the day, and you're certainly more than welcome to stick around and enjoy a civics lesson if you so care to. But if you've got other things to do with your afternoon on what looks to be a lovely late July afternoon, that's certainly understandable. You can call into the zoning board office in the morning and find out how we ruled. If you take out pen and paper, I'll read this number off a couple of times for you. The number for the zoning board office is 410-396-4301. Again, that's 410-396-4301. You will, however, need to wait until you receive the formal written outcome of your case. That should be forthcoming in about 3 to 4 weeks. We certainly ask that you please not build in the city of Baltimore without first obtaining proper permits. If you've not already done so, if you're here in opposition to any case, we please ask that you sign in on our sign-in sheet there. The sign-in sheet allows us not only to know generally which cases have opposition, but also allows us to know who needs to receive those aforementioned notices I just referred to. So if you sign in, we can let you know what happens in the case you're here today on. Additionally, if your case gets postponed for any reason, we need to be able to contact you and locate you to let you know when the case will be going forward. The procedure for today, when we call the cases, this is after we deal first with our consent agenda, but when the cases are called, the applicant or the appellant will come and they'll stand to our left, or your right. The opposition, if any, will stand to our right or your left. Everyone will get sworn in, and once that happens, we'll first turn to the appellant to give us their side of things, let us know what the issues are in the case, answer any questions from the board, tell us what it is that they have planned. Once they're done with their presentation, the opposition will then be given a chance to present their side of things. And once they're concluded, we'll be going back to the appellant to respond to any points brought up by their opposition and to offer any closing statement. We won't be going back and forth and unnecessarily keeping folks here all night. We will generally be calling the cases in which they appear on our docket after we first get through some preliminary matters. First, we have our consent agenda, and the consent agenda are those cases where the zoning board staff has previously reviewed these files and determined that there is sufficient information to approve these appeals. We'll call all of the consent cases as a group, and once everyone is up here, we will get you all sworn in, and you'll be given the opportunity to offer any supplemental information that you'd like to have added to the record at that time. So you'll want to listen up to see if you're on the consent agenda. The first person will line up right here, and everyone else will line up behind them. If you can please try to stay in the order in which you're called, that'll help ease things a bit. 2014-159, 1314 William Street, Bernard Mayers, care of Aaron Stubbs. Calling again, 2014-159, 1314 William Street, Bernard Mayers, care of Aaron Stubbs. All right. Next case, 2014-225, 108 North Utah Street, Charles Belfour. Okay. And 2014-226, 106 North Utah Street, again, Charles Belfour. Mr. Belfour, you can get a little bit closer. Next case is 2014-260, 3120 Hudson Street, Valeria Coster. Next is 2014-261, 1033 Light Street, Biblos Restaurant, care of John Liparini. Next is 2014-266, 1215 East Fort Avenue, Caroline Hecker. 2014-267, 508 South Milton Avenue, Michael Coster. 2014-268, 812 Stiles Street, Julie Tice. 2014-269, 1104 Bayless Street, David Schiavone. 2014-271, 2002 Goff Street, David Roselle. And 2014-272, 4017 Liberty Heights Avenue, Joseph Woolman. Ah. 2014-270, 416 through 18 East 30th Street, Heather Papania. Okay, I think we got everyone up here. If you can all raise your hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth? I do.
Okay, first case is 2014-225, 108 North Utah Street, Charles Belfour. We'll also call this together with 2014-226, 106 North Utah Street, also Charles Belfour. Afternoon, you're Mr. Belfour? All right, Mr. Belfour, as to 108 North Utah Street, we have that as an application to house 5 dwelling units with first floor commercial space as a mixed-use, multiple-family attached dwelling. Is that correct?
Yes.
Okay. And as to 106 North Utah Street, we have that as an application to house 4 dwelling units with first floor commercial space as a mixed-use, multiple-family attached dwelling. Is that correct?
Yes.
Okay. Do we have staff reports? Well, from, not staff, rather, Mr. French, for the Planning Department.
Thank you. Martin French from the Baltimore City Planning Department. The Planning Department recommends approval of each of these appeals. Thank you.
Thank you very much. And Mr. Belfour, was there anything further you'd like to have added to the record? All right. Zoning Board staff, having previously reviewed the application, determined there is sufficient information to approve your appeal. Appeals. Good afternoon. Next case, we'll call these together, 2014-260, 3120 Hudson Street, Valeria Coster. And Mr. Coster, I understand you're here on that case, is that
Yes.
correct? All right, and 2014-267, 508 South Milton Avenue, Michael Coster.
Yes.
All right. Mr. Coster, we have as to 3120 Hudson Street, we have that as an application to construct a second floor overhanging rear addition with rooftop deck, is that correct?
Correct.
And as to 508 South Milton Avenue, we have that as an application to construct a second floor rear addition with second floor rear and rooftop decks. Is that correct?
Correct.
Okay. Mr. French, anything for the planning department?
Planning Department has no comment on either of these applications. Thank you.
Thank you. And Mr. Coster, was there anything you'd like to have added to the record?
No, sir.
All right. Zoning Board staff, having previously reviewed the application, determined there's sufficient information to approve your appeals.
Thank you.
Thank you. All right, 2014-261, 1033 Light Street, Biblos Restaurant, care of John Liparini. So we have this as the application to use the first floor as a restaurant with outdoor table service as accessory to the restaurant use. Is that correct?
Yes.
All right. Mr. French, anything for the planning department?
Yes, thank you. This case is very similar to one which was heard by the board a couple of weeks ago for 1035 Light Street, and the comments are actually essentially identical except for the size of the seating area itself. The department is recommending that the planters that were put into the sketch plan not be approved by the board, as they would not leave sufficient unimpeded pedestrian access on the sidewalk outside. That said, the department is recommending approval of this appeal, specifically if the carry-out food shop is converted to a restaurant, as the last recorded use available to the department was a carry-out food shop, and subject to these conditions in addition to any other conditions that the board might establish. A minimum of 6 feet of the sidewalk must remain clear and unobstructed for pedestrian use. The capacity of the outdoor seating area will be not more than 3 tables and 6 patrons. The tables will be limited to those that can seat 2 patrons and are to be kept against the wall of the building. There will be no outdoor bar, no outdoor music, jukebox, or other form of entertainment, and all patrons must be seated for dining and served by wait staff. Thank you.
Thank you. All right, Mr. Liparini, were those conditions stated by the planning department acceptable to you?
Yes.
All right. Was there anything further you'd like to have added to the record? All right. Zoning board staff, having previously reviewed your application, determined there is sufficient information to approve your appeal. Thank you. Good day. Next case, 2014-266, 1215 East Fort Avenue, Caroline Hecker.
Good afternoon. Caroline Hecker with Rosenberg Martin Greenberg on behalf of the applicant. I'm joined by Stanley Fine and by Mark Saperstein, the developer.
Afternoon to all of you.
Thank you.
Ms. Hecker, we have this as an application to use a portion of the premises known as Building Number 2, including constructing a 4th floor addition for offices, business, and professional other than accessory within a mixed-use industrial park. Is that correct?
Yes, that's correct.
All right. Mr. French for the planning department.
Thank you. The department recommends approval of this appeal, provided that the applicant satisfies the off-street parking requirements of the zoning code, that the off-site parking area on an adjoining lot which would serve this proposed use receives approval from the Site Plan Review Committee and is constructed according to those plans, including provision of shade trees internal to the parking lot if its interim status extends beyond 2 years from the date of this board's approval. Thank you.
Thank you. And Ms. Hecker, were those conditions stated by the planning department acceptable to your client?
Yes, they are.
Okay. And was there anything further you'd like to have added to the record?
I would like to add this to supplement your record.
All right.
There is a letter of support in there from the Locust Point Civic Association, which I believe you have already received.
Okay. Dealing with that. Anything further?
Nothing from us?
I
Oh, well,
would like to just add one thing not related to this case. The board was kind enough to indulge me 2 weeks ago, and I just want to show the board that my daughter had the baby on Saturday, 11 days late.
Congratulations.
So I just wanted to complete the circle. Thank you.
Congratulations, Mr. Fine. Anything further?
that's it.
After that?
How can I follow that?
How are you going to follow that?
In that case, zoning board staff, having previously reviewed the application, we determined there is sufficient information to approve your appeal.
Thank you.
Thank you. Good luck. Next case, 2014-268, 812 Stiles Street, Julie Tice.
Hello.
Afternoon, Ms. Tice. We have this as an application to construct a 3-story rear addition of these premises. Is that correct?
That is correct.
All right. Mr. French, anything from the planning department?
Planning department has no comment on this application. Thank you.
Thank you. Ms. Tice, anything you'd like to add to supplement the record?
Not to this, but the 315 William Street, I got a text request from Aaron Stubbs that I act on his behalf since he couldn't make it.
Okay, we'll get to that in a minute.
Sure.
I guess that's 1314 William Street?
Yes, I'm
Okay,
sorry.
that's okay. All right, and you said you had nothing to offer to supplement the record,
That
correct?
is correct.
All right. Zoning board staff, having previously reviewed your application, we determined there's sufficient information to approve your appeal.
Thank you.
As to 2014-159, 1314 William Street, you're appearing for Mr. Stubbs?
Yes.
Okay, we have this as an application to construct a 3rd floor rear deck and access to a 3rd floor rooftop deck. Is that correct?
Correct.
All right. Mr. French, anything for the planning department?
Planning department has no comment on this application. Thank you.
Thank you. All right, and Ms. Tice, anything to offer to supplement the record?
No.
Zoning board staff, having previously reviewed your application, we feel that there's sufficient information to approve your appeal.
Thank you.
Thank you. 2014-269, 1104 Bayless Street, David Schiavone. Afternoon, sir. How do I do with that name, by the way?
Pretty good. It's not too bad.
We have this as an application to construct a one-story attached rear garage on the premise. Is that
Yes.
correct? All right. Mr. French, anything from the planning board?
Planning Department has no comment on this application. Thank you.
All right. And Mr. Schiavone, anything
No.
to add to supplement the record?
No.
All right. Zoning board staff, having previously reviewed your application, we determine there's sufficient information to approve your appeal.
Thank you.
Thank you. 2014-271, 2002 Goff Street, David Roselle.
Yes.
All right, Mr. Roselle, we have this as an application to construct a first floor side addition and second floor rear addition with a rooftop deck. Is that correct?
Correct.
All right. And Mr. French, anything from the planning board?
Planning Department has no comment on this application. Thank you.
Okay. And Mr. Roselle, anything to supplement the record?
No, thank you.
Zoning board staff, having previously reviewed the application, we determine there's sufficient information to approve your appeal.
Thank you.
Thank you. 2014-272, 4017 Liberty Heights Avenue, Joseph Woolman.
Good afternoon, Mr. Chairman.
Afternoon, Mr. Woolman. We have this an application to construct a four-story front addition onto a nursing home. Is that correct?
That's correct.
All right. And Mr. French, anything for the planning department?
Yes, thank you. The applicant provided architectural drawings yesterday for review by the department. The department is satisfied that they will in fact improve the appearance of the building on its Liberty Heights facade. Therefore, the department is recommending that approval of this appeal, if granted, be conditional upon the applicant constructing the front addition to the existing building in accordance with the architectural design and plans dated July 28th, 2014.
Okay. And Mr. Woolman, are those conditions acceptable to your client?
They are, thank you.
And was there anything further you'd like to add?
Just two things very briefly. Copies of the plans Mr. French just referenced for the record. I would also note for the record there is a patio that's being moved that was not in the original plan filed, and that is reflected in this plan. I do not believe it affects the nature of the appeal, but I want to be clear on the record. And then finally, a copy of email sent to the Neighborhood Association advising of our request. They're all the same.
Okay. One for the file. And for your edifications. Anything further?
Nothing further.
All right. Zoning board staff, having previously reviewed the application, determined there's sufficient information to approve your appeal.
Thank you.
Good luck. 2014-270, 416 through 18 East 30th Street. Heather Panania.
Yes.
All right, Ms. Papania, we have this as an application to use the premises as an outpatient physical therapy office with a pharmacy. Is that correct?
Correct.
Okay. And you have some assembled guests with
Yes,
you.
the owners of the company.
Okay. Gentlemen, could you care to identify yourselves for the record?
Dr. Ali Kanji, nice to meet you.
Good to meet you.
Sure, A-L-I, first name. Last name Kanji, K-A-N-J-I.
Mine, Y-I-N-K-A, first name, and the last name is A-D-E-P-O-J-U.
Okay. And you've also got Ms. Guida here. I understand that there's an agreement between the parties?
Correct.
And I brought copies for the board. And good afternoon, Sharon Guida, Chair of the Charles Village Civic Association Land Use Committee. And I'm here to put that agreement on the record. It has been signed by both gentlemen who are also members of the LLC that owns the property. So they're representatives of the business and the property. And the support of the Able Improvement Association and the Charles Village Civic Association is conditioned upon the property owner's agreement to those conditions, which has been made, one of which is that the use be accessory to the physical therapy use next door, the use of the pharmacy. And so, subject to those conditions, which the owners have agreed that their use would be subject to, we give our support. And I also wanted to add that there's a letter from Mary Pat Clark, which they're going to introduce now. Thank you.
Do you have the letter from the councilman?
Yes.
Okay. All right, and Ms. Patania, did Ms. Guida accurately state the agreement as you understand it?
Yes.
Okay. And Mr. French for the planning department.
Thank you. Planning Department noted that the two uses, the pharmacy would be a retail use, which would not be permitted in this zoning district as a principal use, and therefore could only operate as an accessory use. And therefore, the department recommends that approval of the appeal be subject to the condition that the pharmacy be an accessory use to the professional offices. Thank you.
Okay. And I'm going to imagine, Ms. Pania, that the condition stated by Mr. French is acceptable to you as well?
Yes.
Okay. And was there anything further from, I guess, either party to add to something there?
No.
All right. The zoning board staff, having previously reviewed the application, and given there's sufficient information to approve your appeal.
All right, thank you.
Good luck. Okay. All right. Yeah. Okay. All right. The next group of cases which we'll address will include cases where opposition is signed in. Frequently, we found that opposition is the result of either a lack of communication or a miscommunication between the parties. And it can be useful to offer the parties an opportunity to enter into a dialogue and try to resolve any issues that they may have, for the applicant to discuss their plans with their opposition, communicate what the scope is, and to answer any questions, and for the parties to try to see if they can resolve their differences. Obviously, if two opposing parties approach the board on opposite sides of an issue and ask the board to resolve it, one party is bound to go away from that exchange dissatisfied, and this is your opportunity to avoid that unhappy fate. So when I call the cases that have opposition, we'll ask that you just stand where you are. You certainly don't have to take the opportunity to have a discussion with your opposition or with the applicant, but we certainly do encourage and appreciate it. First case we have opposition is 2014-258, 1609 Bank Street, Adnan Salazar Martinez. Okay, and who signed in on, oh, you can just stay there. Who signed in on that one? Okay, and folks, have you had an opportunity to try to have a discussion with the applicant, see what can be accomplished? Okay, Mr. Salazar Martinez, any desire to talk with the opposition, see if you can get something settled? No? Okay. Have a seat. We'll call you in turn. Next case where we have opposition is 2014-265, 3459 Chestnut Avenue, William Hurd.
Would resolve the matter, Chairman.
Okay, all right, great. Have a seat, and we'll call you in turn. All right, we're going to skip around a little bit. First case, 2014-259, 1401 Decatur Street, Kelly Scott's. All right, afternoon, council. We have this as an application to continue to use the first floor of the premises as a tavern. Is that correct?
That's correct.
Okay. Those giving testimony, raise their hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. And do we have staff reports?
Planning Department will report in the meantime. Thank you. The department noted that the application states that the property is currently vacant, although its last permitted use was a tavern, which is a non-conforming use in this R8 residence district. And the department therefore is recommending disapproval of the appeal unless the applicant demonstrates that nonconforming use of this property as a tavern has not been discontinued and abandoned, as defined in the zoning code. Thank you.
And Mr. French, for clarification's sake, you said that records show that the property was vacant.
The application stated
The
the property
application,
was
rather.
vacant.
Do you have any record as to prior use or anything like that?
We only have the record which indicates the last permitted use or authorized use was a tavern, but we do not have a record of when the tavern use became vacant.
Okay. All right, Mr. Kudinski? Well, actually,
We do have a letter also.
we do.
Locust Point.
Locust Point Association indicating that they had a meeting and voted unanimously to support this request. That concludes staff report.
Thank you. All right. Mr. Kudinski?
For the
floor is
record,
yours.
Melvin J. Kaninsky. Let me try to fill in the blanks here if I can. This property was owned by Mr. Prashant Kumar, and this is his wife, Parul. Mr. Prashant Kumar, in '99, had a very severe accident where he lost both his legs, as a result of which, he was acquiring some properties, and he acquired this property, and probably in a moment of weakness at an auction. He never occupied it, but he sold it, and it seemed like every party who he sold it to wound up having a problem. As a result of which, due to tremendous legal battles, we had to go and apply for the license to be transferred back to him as a secured party, and I'll just give you a copy of the applicant with the liquor board showing in April this year. We filed for renewal as a secured party. Along with that, there were two other lawsuits that were filed, one for back rent and to get repossession of the property, and one for confessed judgment. The suit for the rent and repossession, I'm in closing, took us forever to get a judge to sign an order. Also in the confessed judgment, wasn't until recently that the judge, Judge Lawrence Fletcher Hill, signed an order giving us the right to go forward. In the meantime, Mr. Prashant became very ill. He just passed away about a month ago. He died, and his widow now is trying to finish up this transaction. They had sold the business to the lady here, Kelly, who went and got approved by the liquor board, and now we're in the process where we are today. When the last time it was operated by Mr. Hoffman, who the name may be familiar to, he's president of the Firefighters Union. We have no idea. We could never get possession of the property. We finally got it, and I'll give you these as exhibits to show it was not for lack of trying to get repossession and having the license transferred. The present person who is applying for this application, Ms. Kelly Scott, is one of the purchasers. She has some pictures showing it's always been a tavern. It's set up as a tavern. It's been nothing but a tavern. The Locust Point Association met with them. Unfortunately, they're black and whites.
Mr. Kudinski, I think you said it, but just tell me again, when did you get possession? When did your client get possession?
Well, we kept filing, wasn't until we got the license and everything, until maybe, I'm trying to remember where it was exactly, and I don't think Parole even knows the exact date, because she never handled most of the things her husband did, in fact, his untimely death. But it was not until lately. Now, I can't tell you what date. We had filed for an ejectment. We couldn't get the sheriff to get in there. We had to file in suitcases. And then finally, maybe it was towards the end of last year or so, that he finally got the possession that he wanted to sell it to Ms. Scott here. Can you state your name and address for the record, please?
My name is Parul Kumar. I live at 3737 Bedford Drive, North Beach, Maryland.
And now, is the information I gave, is that correct?
Yes.
Yeah, and then mainly, again, I know you have the death certificate. We believe that your husband passed away. And this is one of the assets of the estate, is that correct?
Yes.
And your husband handled most of this all the time?
He always did, yes.
Okay. And would you state your name and address for the record, please?
My name is Kelly Scott. I live at 3607 Keystone Avenue, Baltimore.
And you've been approved by the liquor board and the community and so forth, is that correct?
Yes.
And you're going to be, you're purchasing the license and the fixtures from Ms. Kumar?
Yes, and then we will be leasing the building from her.
That's all I would have.
The records that we have show that the last permit was issued in 2007 to continue the use. First floor of the premises as a tavern.
I understand that, and I know Mr. Huffman was in there.
We have no indication that there were any other vacant building notices or anything like that issued.
I'm on your side, Mr. Tanner. I'm trying to help the estate out here. But a few times I get letters from the community, I might have a lot of people. Or Mr. Saperstein maybe did a bunch there. So one more juice than I have. Thank you.
Thank you. All right, any questions? All right, thank you.
Thank you very much.
All right, 2014-265, 3459 Chestnut Avenue, William Hurd. Afternoon. Mr. Hurd?
Yes.
Okay, we have this as an application to construct a one-story detached garage in the rear yard. Is that correct?
Right.
All right. Will you gentlemen raise your hands and be sworn, please?
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Do we have staff reports?
I have no report.
Planning department has no comment on this application.
Thank you.
Thank you. Okay, Mr. Hurd, why don't you tell us what it is you're planning? And I guess you guys said that you have worked something out, so you can work that into
He wanted me
discussion.
to limit to 250 square feet. I have no problem. It will be 12 and a half by 20 building, single story.
Your name, sir?
William G. Hurd, H-E-R-D.
Okay. So it's gonna be 12 by 20?
12 and a half by 20.
12 and a half. And I'm looking at your drawing here. And the garage would be looking at it, in the front of the property, you've got indicated there's a front yard, then there's the house, then there's a backyard consisting of a space that's, on the drawing, 61 feet by 14 and a half feet. And then there's a parking pad that's 24 feet by 14 and a half. And then it says alley. This is a 20-foot alley in the back there. Where would the garage be located?
I have a picture. Is that good?
Well, I've just got this drawing here that I guess you submitted.
Right
with
by the alley.
Okay, so where it says parking pad?
Yes.
Okay. Thank you. And sir, if you can state your name for the record, please?
Wayne Giosa. I'm the abutting property owner.
Okay, and can you spell your last name, Mr. Giosa?
Gioioso.
Okay. And Mr. Gioso, did Mr. Hurd state your agreement accurately as you understand it?
Yes, with the understanding, I mean, the only way, this property is so small that the access to the alley, as to some of the other ones there, is going to have to be through the garage, because there's not enough space to go around the side, which where I own the property, because on the one side, Mr. Chairman, there is this is the space that's left. This is a wall that's up against the property this time, but it leaves very little space. But the other thing is, on my property, this goes out 2.5 feet. This garage, there's an existing garage on my property, which is 14.5 feet. That goes out 2.5 feet, and then the garage goes back.
Okay.
So it's gonna, there's just no way other than to he'll have to put the garage door up put a door in the back towards his house and go through his garage to get out. There's no other way other than to put a door going on my property.
Okay. And I imagine that since the property dimensions are, it's only 14.5-foot wide lot, if it's gonna be a 12.5-foot wide garage, you're gonna be taking up pretty much everything but for 2 feet. So, we can keep these, or, all right, we can
Would
incorporate
it be
those.
centered, like with 1 foot on each side, or would it be to one side with a 2 foot? You know what I mean?
Well, if you look at my picture, you can see there's the other property owner, has got his pad elevated, and it's a tripping hazard.
Sure.
I really think the best thing to do is, put it at dead center, 6.25 foot both sides, and maybe fill in that with something, so it's not that tripping hazard. That property owner on the other side of him, you can see that wall is a tripping hazard. It's elevated.
We're gonna have trouble getting in and out, because I'm only gonna have about 11 feet to get a car. The lady that lives there parks her car there. And when you pull out, you've got this 2 blind spots, and you're gonna pull out into an alley. It's gonna be a dangerous situation. I understand he has a right to have a garage there, but to get in and get out of here is gonna be a very dangerous situation. So maybe if he had it to the other property where there's no other garage. On this side, it's fine, there is a garage. He wants to build a garage here. So they come up, flying up and down that alley. When you get out, you gotta ease out like that, but you also, to get in, there's a light pole right here. So it's gonna make it very difficult to get in and out of my property.
It might be a little bit tricky in there. I know that sometimes people utilize mirrors to be able to address the blind spot issue, but it sounds like you guys have something worked out, and you certainly are knowledgeable enough about the layout of the garage and the alley, the garages and the light pole and the alley. That it sounds like you've got something
Can you agree
workable.
to go north the 2.5 feet? Or you don't even have, what do you?
I don't think that you need to resolve that right now.
Okay.
You can, the approval will read, as you said it, that the dimensions will be restricted to 12.5 by 20 feet, and then if you can submit a revised drawing just showing the
For the
location.
building permit.
Yeah, we'll need it, we'll incorporate it into, we'll need it for our records, but we'll incorporate it into our decision.
Okay,
Okay?
thanks.
All right, thank you very much,
Thank you,
gentlemen. Thank you.
Thank you.
Thank you. Okay. 2014-263, 511 through 19 South Clinton Street. AB Associates, care of Nate Pro.
Good afternoon.
Good afternoon, gentlemen. All right, Mr. Berry, we have this as an application to subdivide the rear lot approved by BMZA 2013-462 into 4 lots, construct 3 3-story attached single-family dwellings with first-floor garages, and the 4th lot to be a common right-of-way access. Is that correct?
That's correct.
Okay. All those giving testimony, raise your hands if you swear, please.
You swear or affirm the testimony that you're about to give is the truth, the whole truth, nothing but the truth?
I do.
All right, do we have staff reports?
We have a letter dated July 28, 2014 from the Clinton Community Association. They write that the association has no objections to the proposed project, and they're happy to see the existing building rehabilitated and occupied. And then we have planning.
Thank you. The planning department has reviewed this application and the site plan that is connected with it. and has noted some very specific points to which the department has objections. The principal objection is that the creation of three additional dwelling unit lots in the rear of the property would create 3 dwelling units with no street frontage, which would also be facing the backs of the other dwelling units to be created by the division of the existing building or the portion of the existing building that would remain on the property. The 3 dwelling units in the rear would be separated from the 3 dwelling units in the front by an open area, which would be a 7th lot according to a tentative subdivision plan that's provided to the department. However, this lot would not be used exclusively for pedestrian traffic, which is a requirement for the zoning code, but in fact is intended primarily for use for vehicular traffic, specifically to provide access to the garages that would be included in the 6 townhomes that would be created by this subdivision as proposed. The department also notes that the 3 rear lots would require substantial variances and would end up with basically 100% lot coverage in each case. And therefore, this represents a very intense infill development type that the department is not in favor of. The department is therefore recommending disapproval of the application for these reasons. It includes interior block housing that would have no street frontage, satisfying the requirements of section 1-156 of the zoning code, and it would face the rear of other attached dwellings. Proposed interior block dwelling units will front on an open lot or private way. It is not intended by the applicant to be limited exclusively to pedestrian traffic, a requirement of section 1-156 of the zoning code. In fact, the proposed private way is intended to be used primarily for vehicular access to the garages to be included in the proposed new townhomes or dwelling units. The extensive variances of setback requirements required for approval of 3 additional attached single-family dwelling units in the rear yard of this property would leave both the new and the existing structures a limited amount of light and air and no unpaved surfaces on their lots in the case of the 3 in the rear, or essentially none. And finally, it is the determination of the department that these requested variances are not required for adaptive reuse of the property as dwelling units and are intended solely to increase the value or income potential of this property. The department further notes that the subdivision proposed would likely be considered unapprovable in its present form by the Planning Commission. Thank you.
Thank you. Mr. Berry, I think that you have your work cut out for you.
Well, let me, first of all, explain to the board what we're looking at, because I hope you have all this. And if you look at your aerial photograph, you'll see that this building, if any of you are familiar with it, was known as the Boys and Girls Club. It is what is, in the front part, a somewhat Georgian-style building that was used for a recreation club for many years. Originally, it was owned by the Salvation Army, and in back of the building, approximately beginning a third of the way back, the entire property is 100% lot coverage. It is basically a gym and a warehouse building that is built to the rear property line. When my clients took over this property and came before the board, we had meetings with the Community Association. This is right in the Highland Town sort of business district, just Clinton and Eastern Avenue. And we, at that time, got approval from the board to subdivide the first 3 properties, which would be a conversion of the existing Georgian-style building into 3 for-sale townhouses with a lot in the back that we always intended to subdivide or propose subdivision for 3 more single-family houses. All of the discussion with the neighborhood has been that. In fact, the discussion with the city going back a year has been that. Because of the historic district and the desire to have property tax credits, we had meetings over many months with the CHAP staff about which part of the older building could we use, if any, or could we tear any of it down and still qualify for the tax credits. And that took many months to ultimately come to a conclusion that the CHAP Commission wanted the entire back wall
essentially saved, including the roof of the gymnasium building, which would make it impossible to renovate for housing. So to Mr. French's comment that this is solely for the adaptive, we could just redo the front building. We had a problem with getting CHAP credits if we tore down any of the back building, even for the front building. So what that has led to is a desire to not go for the CHAP tax, property tax credits, and to go to our original plan to build 3 contemporary houses along the back wall, which the community has supported. They're very anxious of not having a extensive, or I won't say, I don't want to speak for them, but they've approved this plan. And as you know, the Canton Community Association has a rather vigorous review process for this type of project. So what you're looking at in this colored rendering is the 3 homes in the front, which would be within the existing building, a new right-of-way created, and I'll also take exception to Mr. French's statement that this right-of-way as a driveway for cars is required to be 50 feet. The Planning Commission has the ability to reduce that to 40 feet, which is what we are actually proposing here. And in fact, there are numerous subdivisions that have been approved by the Planning Department that have created this 40-foot right-of-way for, in effect, 3 new houses that would front on it. These are the 3 new buildings. I think we've sent you some plans as to what they might look like. In terms of the department's comment that this is an intensive infill, this is a very large property. If you see it, it's considerably larger, 10 times larger than the immediate houses around it. It's zoned for actually 17 dwelling units. We're putting 6. So I would hardly say that this qualifies as an intensive infill. It's in character with the single-family nature of the surrounding properties. And yes, there are variances required because of this new right-of-way that's being created. But we think that the unique standard of the property, which was found by the board in its first approval, certainly carries forward to this approval as well. In terms of limited amount of light and air, I would say that that is not the Planning Department's purview. That is a purview of the building code examiner when it comes in for building permits. Actually, this property has frontage, or these back houses will have access to 3 alleys on the sides of it that will allow windows to be put on the side, the rear, and the side of these 3 houses. So it's not that we're building right up to the property line and there's another wall adjacent to it. So we will have to meet code requirements for light and air. And not only will that be received from the front on this new private right-of-way, but it will be received on the light and air will be received in the alleys to the 3 sides that you can see on the city block plat. So I would argue to the board that if you would choose to approve this, as I hope you would, just as before, we do need to go through a subdivision approval process so that the Planning Commission would have the decision of whether they like the design or they want to reduce it from 50 feet to 40 feet. We think that's fine if the board can approve it with that condition. We are willing to take our chances with the planning staff and the Planning Commission to convince them, as we have had in the past, that these creative interior plans that for these large properties throughout South Baltimore and East Baltimore is something that the Commission has approved in the past. There's ample precedent for them. That's not your job, but we would ask it to not prevent us from going to the Commission and asking for subdivision approval if you can approve the variances, which are, we think, limited in any event.
What's going to be in the center lot that you're leaving open, that's just simply going to be?
It's going to be paved for, and it's going to act as a courtyard or a mews. It's going to give access to both the front houses along Clinton Street as well as the rear houses.
How wide's the alley to the,
I think it's.
I guess that's going to be the entrance
That's
point?
going to be the entrance. That's an existing right-of-way that cars up and, on the other, use for access today.
That is a 13 by 6 alley?
Yes.
According to the block plat. Then there's a 20-foot alley. on the other side that's accessible by way of a 10-foot alley.
That's right. As I said, we've had meetings with the neighborhood about this property for over a year. I think they recognize that we're not taking a property which is completely barren. It's a property which has some historic merit in the front, but no historic merit in the back to even keep as an adaptive reuse. So with that, we think that the proposal, again, 6 units versus 17 units, if this were to be a multifamily building, if we were to tear down the back part, give up the chap credits and put a multifamily building there, parking underneath, we could theoretically have as many as 17 units in the whole complex and then not even require subdivision. But we think that this is a single-family home ownership market. Primarily, what's surrounding it, Eastern Avenue is all commercial, but the houses below the alleys to the south are all single-family homeowners.
Any questions?
So I'd like to think we meet the standards which you've met before for uniqueness, and as I said, if you could approve it subject to the Planning Commission's subdivision approval, we would be perfectly willing to continue our dialogue with the Planning Department on that as well.
One question. You said that the property meets the uniqueness requirement for a variance, and you referenced the prior hearing and approval on regarding this property. As to this plan, what's the hardship, which is the other prong of the variance test?
Well, were we not to be granted a variance to develop any of the rear property, the lot that was created under the previous approval, you would be, I would argue, forcing us into perhaps a different plan that would result in more units for the property, multifamily apartments as opposed to single-family houses. The notion that this property requires the access that the zoning code requires, which is this 40 or 50-foot right-of-way, is what creating the hardship. If we were to be able to narrow that down to something that was, I mean, as a practical matter, we could have a 20-foot aisle, which would give sufficient parking access to both the new properties and the existing houses, 20 feet. Therefore, we could then move the houses toward that 20 feet, thereby creating a rear yard and eliminating a lot coverage variance. But the zoning code at the moment doesn't allow that, so I think that's the hardship that we're dealing with. I think there's ample precedent that the board has. We just had a zoning approval and a subdivision approval down at Race and Fort. Exactly a similar situation where his private driveway was allowed to be reduced from not just 40 feet, but 30 feet by the Planning Commission, overruling the staff, which recommended against it. And, the houses building permit was issued. I don't think they've started yet, but if you're familiar with that property, it's a vacant piece of property. So I think some of these regulations work against sort of a reasonable infill development strategy, which the neighborhood wants. Developers not trying to overtax the property with the number of units. So I think the hardships created by sort of conflicting regulations.
I mentioned that planning is actually looking to change the same regulations that Mr. Barry's speaking of right now. They're actually working to put it into favor that would help us avoid this hardship.
Okay. All right, any questions?
Great,
Thank you.
thank you very much.
All right. 2014-258, 1609 Bank Street, Adnan Salazar Martinez. Come on up, folks. Don't be shy. Okay. All right. Mr. Adnan Salazar Martinez, we have this as an application to use the first floor of the premises as a restaurant. Is that correct?
Yes.
Okay. Well, first, can all those giving testimony raise their hands and be sworn, please?
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Do we have staff reports?
Yes, first we have received at least 20 letters in opposition to BNZA 2014-258 for 1609 Bank Street from the Douglas Place Neighborhood Association and many residents. They write that they have no confidence in the building's owner, Mr. Salazar Martinez, who is the applicant, that while he is a nice person, he has not approached anyone from the community with his proposal. Mr. Martinez previously leased the building to a Club Confetti Bar, and after repeated complaints about his tenant, he did little to address the community's concerns. The Baltimore City Police were called and repeatedly to the property by residents due to parking issues, bar fights, gangs, public urination, and loud music. Club Confetti had multiple liquor violations for disturbing the peace, welfare, and public safety of the community. Fines and suspensions were issued, and the liquor license has been revoked. Also, the owner never contacted CHAP when they installed an awning for Club Confetti, and they were advised to remove or replace the awning by September of 2013. Mr. Martinez has yet to comply. The opposition points out that this area is zoned R8, and according to city code, a restaurant use is not permitted, adding that there is currently no kitchen in this building, and that the establishment has been closed for over 1 calendar year. Under the law, they may not reestablish and must conform to the regulations of the R8 district. They note that commercial properties such as, and I'm assuming there's an address error here, 1618 Martin Seafood and 1621 Bank Street are being successfully converted to residential housing. Additionally, more often than not, there's no parking in this area for residents, let alone accommodating restaurant patrons. They write that the residents have a right to the peaceful enjoyment of their property and homes, and add that they had no issues with the 2 apartments at 1609, as the tenants have been good neighbors. They have also attached a news article referencing Club Confetti's history, and that on May 31st, 2013, the Baltimore City Liquor Board revoked the liquor license of Club Confetti, and that Circuit Court of Baltimore City affirmed that decision. Essentially, that the building has remained closed since May 31st, 2013. We also have received letters from Councilman Crafts and Stokes, who write that they share the concerns of and support the residents in opposition to the appeal. Does planning have any report?
Thank you. Planning Department noted, as the board has previously been advised by the letters from the neighborhood, that this property is located in an R8 general residence district, that it was last authorized for use as a tavern and as a dwelling unit. The applicant is seeking approval to convert the non-conforming use to a restaurant, and the department has no opposition to the idea of converting the existing tavern to a restaurant. However, the question before the board obviously is, what is the length of the vacancy, and does the non-conforming use in fact still exist on the property? The Department of Planning recommends that approval of this appeal, if granted, as determined by the board, be subject to the condition that the applicant obtain a notice to proceed from the Commission for Historical and Architectural Preservation for any exterior alterations or additions, including replacement signage, in connection with an approved use. Thank you.
Thank you very much, Mr. French. All right, Mr. Salazar Martinez, why don't you tell us what it is that you intend to do with the property? If you can also discuss the prior tavern use, as well as any discontinuance of the tavern use, and then how long it's been since it was used as a tavern last.
Well, my idea is make a restaurant, because I still owe a lot of money in the building, and I just try to see if I can make a restaurant. That way I can pay my bills, you know, that's it. But I know what happened before and all that, but that's, I don't want to deal with that no more. I mean, that's why I'm trying to do a restaurant, you know, stay away from problems. I understand what they say, you know, before it was a mess, but I'm trying to do better now. I just want to see if they can give me a chance to make a restaurant. That way I can pay my mortgage, that's all.
Okay. And when was the tavern use last in there?
When we was closed,
Yeah.
it's almost a year ago.
Okay. Do you remember about what time?
No, I don't remember.
But it was sometime last year, maybe about a year ago.
Yeah, yes, it's a year ago.
Do we have our floor plan or anything, David?
I have one over here, if you want to look at it.
Is this existing, or is this what you would?
No,
put in
that's
there?
what I want to do.
Okay. What's in there now?
It used to be a nightclub, just a bar, little bar, and a big space where they used to dance in and all that, in the bathrooms. But I want to do the kitchen in the back, and want to put like a tables in the front and take the bar away.
Do you intend to operate the restaurant yourself?
Well, yes, my wife, she's the one who's going to run it if it will open.
Okay. Was that it?
Yeah.
Okay. Who'll be going first for the opposition?
My name's Victor Corbin, C-O-R-B-I-N. I live at 1615 Bank Street. And my argument is that this is no longer a conforming use. And I provided in an email to the board that the liquor board revoked the license and the use has been abandoned as of May 30th of last year. This is the notes from the Community Law Center of the last hearing that they had. And if you notice under hearing notice, the largest portion, the date of May 30th is on there. Here also is an article from that speaks to the circuit court affirming and that the bar's been closed since May 30th. And here is one last article which came out several days after the license was revoked and the bar was closed. No one from planning came out to speak to any of the residents to see if the bar how long it's been closed. I would argue it's been closed for over a year, and so under the code, it would no longer be allowed to be open. As also, several of the residents that are also have petitioned the board are from, I live across the street from Perkins Homes, and we have residents who are friends of mine that live in Herring Court, and they also have voted to, we've signed on to oppose as well, that there's no confidence that the applicant will run a successful business there. In addition, there's no plan for the cars for people coming in. We have enough problems as it is finding parking, and the district, it's residential. If you wanted to convert it to an apartment on the bottom floor, none of us would oppose that, but to run a business of this kind, we're just not confident that he will do so in a professional manner, and that also there's a concern of this being used as a backdoor way to try to get a B-class license after the restaurant has been operating for some time, and then someone will come back and try to transfer a license there. I know that's speculation, but under the code, because it's been closed for more than a year, it should not be reestablished.
Next.
Hi, my name's Mark Traswitz. I live at 1615 Bank Street.
Can you spell your name, please, sir?
Tarasiewicz. I live in my property since year 2010, and I observed when the bar was there, multiple fights, gangs, all kinds of problem. The bar was operating for many years without running hot water, and nobody in the city, because the city has problems with basically enforcing its own laws. So this business was detrimental to the neighborhood, and our block is changing. Mr. Hansen developed the apartment building. We put like 15 trees, we put flowers, and this block changed. This block doesn't need gangs, fights, blood on the street, and all kinds of problems. And this owner is not bringing any confidence. Even as we speak right now, the site of his building is a mess. Lots of weeds, lots of trash cans, lots of trash bags. This owner is not running a nice business and friendly neighborhood. It's a detrimental to the neighborhood. His awning is ugly, it's trash, rats, all kinds of problems. This gentleman is not taking care of the building. We don't need this. And this is a residential building right now. By the code, it's been closed more than 1 year, and it's R8 use. And if we bring restaurant, we have parking problem, we're gonna have more parking problem. They develop another apartment building with almost 20 units across the street with 10 parking spaces, so we're already gonna have even more parking problem. We don't need that in this neighborhood. We welcome anybody to develop in this neighborhood who is good tenant, who is taking care of the property, and who is friendly to the community. This community is changing. We don't need to give bad example to people who are already disadvantaged living across the street in the Perkins homes. We put roses in our tree pits, and they help us cleaning. I help them cleaning, and it's catching on. We don't need bad tenants and bad people. Thank you.
Can I say something?
In a minute, sir.
Yes, my name is John Cutinelli, Cutonilli. I live at 1606 Portugal Street, which is basically catty corner behind the appellant's place. And prior to Club Confetti, they had Club El Dorado, and they had similar issues with noise and stuff with Club El Dorado prior to Club Confetti. I actually had to sue Club Confetti twice because of noise ordinance violations of the health code, and I've had nothing but issues when with them. I actually tried in 2008 to send a certified letter to the appellant, and it was returned by the mail, so I don't see that he's even, he seems inattentive to the community's issues when I tried to contact him. So I don't see that he's gonna do anything, so that's.
Okay. Do you understand that if, well, as I understand it, the property right now has been vacant ever since the club closed, correct?
Yes.
Okay. And that it appears the applicant wants to try to open it not as a club but as a restaurant and try to get some kind of productive use back into the property, which would then lead to the outside, presumably, being more maintained, and would seemingly, at least from an aesthetic standpoint, improve the exterior presence of the building. If that doesn't happen, then it'll probably just simply sit there as it is, which means that it would just simply sit there and be an eyesore and probably cause you more angst over it.
I live behind the building, so I don't have aesthetic issues for me. I'm concerned about noise and various issues that have been going on since he's owned the building. And that's my big concern, is that he comes in and starts playing music or whatever, and I get disturbed. I can't sleep at night because of because of the uses that have gone on in the past.
Did you consider, and since he's talking about having a restaurant use as opposed to a club use, have there been any discussions about any kind of restrictions to be placed on operation of the restaurant, such as?
I haven't, like I said, I tried to contact him back in 2008,
But-
and he was
but, sir,
unresponsive.
that was, first of all, that was 2008, was 6 years ago. But when you started the hearing, I offered the opportunity for all sides to have a dialogue with one another to try. So that was an opportunity to have that discussion. And it would seem that it could be productive to have that kind of use. One thing I do want to clarify is that what's this section? As I understand it, the use has been discontinued. I haven't actually heard the time period. I guess the closest we get is the May 30th hearing from last year as far as when the liquor license was revoked, though I'm not sure what that necessarily means that the use stopped then. So there's a little bit of a lack of clarity on that. But, yeah, so the board does have the ability to extend any discontinuance if it's only been discontinued for that 12 months period. So it's not quite as clean as you're presenting it to be.
We have, again, we have the discretion to go beyond the 12 months for another 12 months.
If I may, as far as the concern of what the building looks like, it's been abandoned for a year, except for the tenants on the second and third floor. He hasn't come and done anything
Well, as I
about
understand
the
it,
property.
nothing's been.
Yeah, but that shows a little bit of the history of that. What if you haven't done anything in a full calendar year? How do you expect us to have confidence that you're going to do anything correct now? Also, I was at home the day that Mr. Salazar, I saw him after a year. He came by. I was sitting out front watering the flowers in front of our home, and he not once came over and spent like 10 minutes to say, this is what I want to do. I saw it when the poster went up. So if there was really any concerted effort to contact us, he knows where I live. I mean, he doesn't, he's an abandoned owner, an absentee owner. He doesn't live in the city. He doesn't live in the neighborhood. I'm sure it'll be rented out to someone else. And I'm sorry that he spent too much on the building, but that's not my problem. That's not my fault that the building has been
Could it be
remaining.
a problem if the board, despite your opposition, let him do what he's asked to do, and you didn't speak up to try to place any restrictions on that?
But my issue would be that there's community opposition. I mean, we have community
true.
from Perkins Homes, they're opposed. We're opposed because the district is split in this. I mean, I consider us all neighbors, but the district is split in half, so we have two council.
And I understand that, but community opposition isn't the defining point of the hearing.
But if you go back to one of your previous hearings where there was an abandoned use of a tavern, planning recommended not to proceed. And so, that was my argument, that planning has yet never came down to the neighborhood to look at the property, to see what's going on. As Mr. Tarasivic stated, there are weeds almost as tall as this bench right now that are growing on the side of the building. If he was concerned about how the building looked and concerned about the neighborhood, I would be, coming down once a month to check on my property. He doesn't do that. I pick the weeds that are in the gutter. I pick up the trash that gathers next to his building because I don't want the neighborhood to look like with crime and grime. So I go there and I do that with the help of the residents of Perkins and myself, and my partner gets out every Saturday and Sunday and picks up trash at 7 o'clock in the morning around the whole neighborhood. He doesn't do that. He doesn't show. I don't believe that he's going to do that. And nobody here has addressed the issue of parking. How many seats are you going to have in a restaurant? Where are they going to park? The Henson project has 47 units, and yet provides only 29 parking spaces, which is fine because he came to the neighborhood, worked with the community. The Martin Seafood is already only providing 50% of the parking that's needed. Right now, there's nowhere to park. There is Scooter's Crabs, which is in the middle of the block, and currently on a Saturday or a Sunday, when people come to pick up crabs, we have upwards of 8 cars double parked up and down Bank Street because there's nowhere for their customers to park.
I would point out that parking is not an issue in the appeal, though you could address parking as a condition of, if you had worked out an agreement, you could have parking as part of that required agreement.
But I do know that the zoning board does take into account parking plans in the past. They've done it in Canton and in Lower
Sure,
Fells Point.
when it is an issue with those particular appeals, certainly.
But this is just not the right place for a large restaurant. And I think the history speaks for itself. And I think it can't be overlooked about the way that the place was run. And he knew about it. The only time he got involved is when he knew he was going to lose the license. And that's why he went back to the to the liquor board, because he was the secured creditor. He was well aware that there was problems with the bar. He knew for more than a year that there was problems. We spoke to him about the problems almost 18 months before they revoked the liquor license. He did nothing. He didn't change anything. And that speaks
get
to
that
the history,
point.
to what we are going to expect in the future.
Okay, who's next?
My name's Debbie Ritter. I live at 235 South Madeira Street. I frequent to visit and work with this young man at his house, so I witnessed much of the concerns and the grief that the community was put through. And it was founded. But the thing that I'm concerned about is that it's over a year. And my understanding is that they wouldn't be able to do this. Because I was at that hearing when they revoked the license. They have not been open.
Okay, well, that's fine.
I mean,
But what the code says is that the board does have discretion to
can-
extend it.
to
Yes,
extend
that's
it.
correct.
But what he speaks of is true. I've seen it myself. I used to run, jog through the area. I saw what the
Sure,
people
and
went through.
just so that you know, I mean, what my thought is that there currently is a building right now that's sitting there. And nothing is happening with it.
So far,
and
the
but just
community-
just a moment. Nothing's happening with it. It sounds from the accounts I'm hearing that it's a bit of an eyesore, and it is just its condition right now causes a lot of consternation amongst the neighbors. People are upset about the condition of the awning. People are concerned about the condition of the exterior walls. People are concerned about weeds and trash and things. These are all sorts of things that get that creep up when properties sit unused, and these are the kinds of things that don't tend to happen when properties have productive uses made of them.
What would you
Just a
read-
moment.
Sorry.
What you're arguing for is for the property to sit and no longer be productive, which to me sounds like you are arguing for the current condition of it to continue, which I don't think is really a benefit to anyone. I do hear and I do appreciate the concerns about the prior operation of the property. I think that there are ways to remedy that in which this board has endorsed in the past by way of placing conditions on uses and operations of property, and such that property owners then have to abide by those conditions that they've entered into with the community association. I think you saw one earlier today in consent case regarding a use of property which initially the community wasn't supportive of, but because they engaged with the property owner and they worked something out, everyone got something out of the arrangement that they were happy with. And you know, remember what I said when I started this, I guess when I started the opposed hearings, which is that if two sides approach the board on opposing sides and they want the board to resolve it, someone's unhappy, okay? Either they're going to be unhappy, which is a decided possibility, or you're going to be unhappy, which is also a decided possibility. And I think that there are ways for that to be avoided, and I think that there are ways that if this board was given the means to control the kinds of antagonistic uses that were made of the property previously, and to make sure that those didn't happen and that those conditions would continue on with the property, I think that that would be useful. But we don't have that right now. We're only now asked to vote up or down without any kind of restrictions or limitations.
We did.
With all due respect to Mr. Chairman, but Mr. Chairman implying that there is only one solution, give him the bar to make the building occupied.
Stop.
The building
I
is
did not say that there's
residential.
only one solution as to giving it to. I did not say that.
In fact, he's saying the contrary. He's saying there's ways that both sides can get something.
No.
that they-
I'm talking about something else. If there is given, for us, it looks like it's given only one solution. Either the building stays vacant or building stays occupied by restaurant. But the building is residential. Building can have tenants at the bottom and
But we
have
can't-
nice
but-
apartments
but
and can be
sir-
taken
but
care.
sir,
Doesn't have to
that's
stay
not anything-
vacant.
But sir, that's not anything that we can do.
I understand, but there is other solution. Building is residential, can have one more apartment, can be taken care, and everything will be resolved. A restaurant, it's not the only solution here.
But
Thank you.
The point is that although it is possible for other uses to be made of the property, that's not something that the board can effectuate right now. That's not something which is being proposed. So we can't, so I do understand that there are many uses that can be made of property. But we're not being asked to evaluate any other request other than to use it in this way. And there are issues with both sides, and I think that there are ways that both sides can get something out of this, because I think that whichever side the board sides with, I'm not sure that that is a state of affairs that really anyone in the end is going to be happy with.
A lot of times, community associations and the appellant enter into what's called a memorandum of understanding, where the parties memorialize how both parties will proceed. And that's the basis. When we accept that memorandum of understanding, that's the basis for our approval.
Do you mind if I, so I'm Liam Davis. I'm here representing Council President Jack Young. I just want to mention that I believe I heard that Councilman Kraft and Councilman Stokes expressed support for the community's position on this particular property. And I'm here to speak on behalf of the Council President. He is also standing with the community. I want everyone to know here that the people standing before you are very experienced in negotiating with businesses, bars, restaurants, in the Upper Fells Point area. This is a property, though, that for years was an extreme nuisance. And it was something where, at least from our perspective at City Hall and at the Council President's office, they were going out of their way to work with them continuously. And that's why they don't want to enter a memorandum of understanding, for fear that it's just going to be a waste of time. So when they see the law on the books that says, well, after a year, the non-conforming status, it kind of gets thrown out. That's what they were going for.
But
And
just so that we're clear, because I'm sure that the council president's aware of what the code says, it says that under 13407, discontinuance or abandonment, in accordance with subsection 7, modifications, continuances by board of this title, the board may extend the time limit for discontinuance for one or more additional periods. In no case, however, may the total of the additional time exceed 12 months.
Yes, sir.
So I do understand, and we've encountered it in the past, where there's been a misunderstanding as to what the law actually says. But that's what it does say.
But sir, do you mind if I just say something?
Yes, please.
It doesn't say that you have to grant them an extension.
It does not. It does not also say that we don't have to do that. It doesn't say that we have to do either. Both sides have the burden to appeal to our good graces.
There was a full year for them to come before this board. A full year. Nothing was done until after that year.
Sure.
Now we have the support of the city council, both city council people who represent these communities, and the city council president, and surrounding neighborhood associations that have dealt with this facility, or with this property for years, had issues. Now we're going to have the same owner, who, I'm not sure, sir, if he has much experience operating a restaurant, but it sounds. I guess the council president, speaking for the council president, we understand why the community is very concerned here. There's a law in the books. It says after a year, if they haven't come before you, it's non-conforming. You don't need to grant them the extension. Just like I know you can grant them, but there's nothing that says you have to.
That's correct. And like I said, the burden is on both sides to appeal to the board. The board does have discretion beyond that 12-month period. And there are cases, including cases which we've had as recently as today, where the board has extended that time period. We do so for various different reasons. And the prospect that the board has to consider is what's going to happen with the property, and I think that both sides have sort of presented situations that have certain unattractiveness to it. The applicant comes to the board and he wants a blank check to operate a restaurant. The board is completely aware of the prior history of the use and the questions that arise from that. The community comes in and says that there's this problematic property, that there were uses that there are problems with the prior use, and that there are problems with the current condition of the property, and argues for that really to continue. And
do you mind if I chime in?
If I may complete. So neither side really presents a situation that is completely appealing. Both sides have issues and problems. And I think that there is a way out for either side. And I say this sitting here trying to evaluate the arguments that are being raised by not just the applicant, but also the opposition.
Fair enough. But I do want to say that if you look at the fact that this is a commercial establishment in the heart of a residential community, one of the biggest problems associated with the former operation was that it would be late at night, customers would spill out, and residents, whether they're adults or kids that have school the next day, would be woken up in the middle of the night. And kids that would have to go to City Springs City Springs school the next day, their night's disrupted, they get to school late. I mean, there's major ramifications when you have a commercial establishment in a community where probably shouldn't really be. If you want to have a restaurant, Broadway Street's a commercial corridor.
Is that the type of thing that a memorandum could address? I mean,
If you can enforce it, you
Yeah.
can enforce all things. I was here one time on a hearing, remember, I raised my hand, and it was 3 things. It was another establishment, and you even addressed that. And you said, well, we're only gonna be able to address 3 items out of 10 on the memorandum of understanding. That was a valuable lesson I learned. I didn't know that. I mean, I didn't know you were restricted, that you were only gonna be able
Well,
to enforce that.
If I'm remembering it correctly, I think that there were a number of items there that weren't zoning-related items.
And that's my point.
But the issues that you've spoken about concerning operation, concerning hours of operation, concerning noise levels, concerning capacity, all of those things are things that the board can and regularly does address. And those are all the issues, even extending to, we've had cases where people have had agreements as to placements of security cameras, exterior lighting, signage. All of those things have been things that this board has previously addressed in other memorandums of understanding, because there's been an engagement by the sides to try to make sure that they get those kinds of things in. That's where I'm seeing the opportunity to do something, because, as I said, sitting here right now, all the board is asked to do is to vote up or down for either side. And really, the concern that I've been voicing is that there's problems with both of those situations, because there are significant negative effects that come from voting to simply up or down as to one or the other issue. And just so that we're clear, because frequently it's the case where community members may not really understand the board's view of community concerns. We're all city residents. We all live in various areas of the city, where, including certain of us, live in areas exactly like you've described. That is, we live in residential areas that are adjacent to commercial areas, that have commercial establishments within the residential portions of those communities. We face the same concerns as far as noise from places like bars or taverns and the like. We don't treat those concerns lightly. We certainly do take them into consideration. The other thing that we also have to take in consideration is that it's the very real situation that you're talking about the rights of a property owner to what they can do with their property. There are certain constitutional concerns that play into that. So the board has to address both of those concerns. Now, there are, I think that the code does a good job of having the board consider those. But when we make our decisions and we make our considerations of each of these cases, that's the kind of calculus that we have to do. We have to take into consideration those very concerns that you spoke about, and we bring to those considerations the perspective of our own lives when we're not sitting on this board.
I would also argue that.
But I think that we're getting a little bit
far afield.
Well, one
but-
thing that I wanted, you continued to mention about what the property, your concern is about it being left empty. And I live next to a building right now that's been empty for 4 years, and the condition is fine. The bank, it's a foreclosure. We're currently trying to purchase that once it hits the final phase. It's been 4 years we've waited with a vacant home next to us, and we have already purchased another property on that block. So to say that it's going to just remain vacant, I don't believe that, because properties on that block are being purchased constantly, and I'm sure if for some reason, if he financially is unable to maintain that property, there will be someone that will come in. Developers are coming in and purchasing up properties all along this area because this is the last available bastion of cheap housing stock in Upper Fells Point. I myself have moved from Patterson Park, right next to Patterson Park, and purchased 2 homes over here and put them back on the tax rolls. So to say that that they're going to remain vacant and an eyesore, I'll never let that happen, even if I have to purchase the property myself. You know, I just feel that, I hope you will not just use that as your excuse to extend this beyond the year. I'm asking you to have faith in the community that we've lived there for 4 years and that we know what's best for the neighborhood. And if he wants to come back a year from now, or a month from now, and put in a new application for a multi-dwelling unit, the community would be more than happy to talk to him about that. This is just not the right place for a restaurant. You know, it's large enough that he can actually put 2 units there. Rental market in that neighborhood are going quite high, so there is plenty of opportunity for him to recoup any losses rather than just doing a restaurant.
Let me just ask you a question, a clarifying question. So if this particular owner of this property sold the property tomorrow, and next month the new owner came in front of the board to petition opening a restaurant, you would not oppose that?
No, we would oppose
You would
that,
oppose
yes. It has nothing to do with Mr. Salazar, or the type of restaurant. If it's it could be soul food, it could be Chinese, it could be Thai, it could be Hispanic. I'm Hispanic myself. This has nothing to do with the fact what kind of restaurant or anything. It's not, we have small children finally coming and playing up and down our street, you know, with the help of Councilman Kraft and President Young's office. We've greened the whole street. 15 trees were planted, 20 rose bushes. We keep the neighborhood clean. Even we do it ourselves. There's only us there. We're the only 2 residents that live there, and he lives behind us. We have kept our neighborhood intact, and this was a challenge. I'll be honest with you. I was nervous moving over there at first 4 years ago. I had never lived outside of, you know, Upper Fells Point over by the Patterson Park, and we made a commitment to really change this neighborhood. And because of what we've done, you can see people park on our street now. That could be it's a double-edged sword. People around South Broadway say, oh my God, your street's nice. You work out of your house. I see you out there every day. You know, so I park my car here. And, you know, I watch their cars. You know, I keep an eye on everything. You know, I am highly vested in the neighborhood. And I'm appealing to the board that we will not allow this to remain an eyesore. You know, I was just out there this week and I picked all the weeds in the gutter because I know what the city code. I understand what you're saying about MOUs. I have negotiated them in my role as a president in another neighborhood association numerous times, but this gentleman did not come to the neighborhood. He was contacted by Douglas Place. I was told by the president. Then he was told to contact her back because she had a problem and they had to reschedule. Do you know when he called her? Yesterday afternoon. Yesterday afternoon at 3 o'clock. This shows his commitment. That's no commitment. He knew since July, he applied on June 1st. He knows where I live. I've been more than open.
Well, you also have the opportunity to go outside and talk now.
I'm not confident that he's gonna uphold any agreement that we have. And then we're gonna go full circle back to where we were again. And then
But
are
haven't
you,
asked.
excuse me?
You haven't asked. He's standing
Nor
right here.
has
Would you
he.
like to ask him to step out and? Well, here's an opportunity. This is what the chairman's been asking.
But
pretty
I
much
did,
for the whole
I
meeting.
talked to his attorney when he was going in front of the liquor board, and we tried to negotiate a
That's
settlement
right,
then,
the
and
other-
it
Mr.
never
Sal-
happened.
Mr. Salazar, are you willing to step outside with the opposition?
I don't really want to talk.
Okay, that answers my question. Thank
Can I
you.
speak, please?
Can I come up front?
Yeah, I need to speak it so we can.
Just a minute, sir, just a minute.
But that answers my question. Thank you.
Um,
That's clear.
I think that was everyone for the opposition. Was there anything further?
Can I just say one thing? Because I was outside of the neighborhood, I come and visit it and actually witness some things. And I will say that the community, these two gentlemen, reached out to the licensee at the time, the owner of the property, several times, even made suggestions. I actually sat in on 2 or 3 meetings. When you talk about trying to work with them, invited them in their home. I was in the home. I heard what was said. I heard how they did everything in their power to try to work with them. When that license was taken away prior, I'm a witness to that, they tried prior to that to work with them. I haven't seen 2 people in the community come to them and try to work with them. Now, you can understand why they do not have the confidence that they're going to follow through. So it's not about them holding up their end and trying to reach out. They did 3 different times. I was in 3 different meetings. They invited them in their home. They did everything. So if you're looking at this as something that they didn't want them there, it's not the case.
One last thing, and this is what I don't really understand either, is it, if there is a problem, if you're having trouble paying your mortgage, how are you going to convert this property into a restaurant?
Who want to have a property?
Well, just that, taking that as rhetorical point, but point taken. Okay. Mr. Salazar? Was there anything further?
I just want my friends.
Okay, sir, and your name for the record?
My name is Robert Holmes, and I just want to clarify a few things that I've been hearing over here. Number one, the character assassination. I'm going to give you a little bit of information for the misinformation. Mr. Alazar does work and live in the city. Not only that, when they said he doesn't do anything in the city, he has taken 5 homes. East Baltimore, Federal Street, almost the whole block renovated, and there are people living in there, and they're productive, and beautiful homes. That's what he does. He does construction. One of the hardest working men that I know, fair, honest, and for them to say that he's not caring about his property, that's not true.
Well, I think that there's been testimony that
Yes.
there's significant problems with the property currently.
Right, I understand that.
So are you saying that that's not the
No, I'm
state of
saying that
affairs?
when it comes to repairing and taking care of property,
Okay.
he's good at that.
Sir, where do you live?
I live at 1626 Glen Eagle Road, and I own property on Federal Street, Huffman, and Valley. You know, I own property. I've been in the city for all my life, for 62 years. And
And do you live in this neighborhood?
no, I don't.
That is the-
I don't live in that neighborhood, but I've been working with him when the bar was being closed to try to get it back on solid ground, but
And
that
was-
didn't happen.
And was he operating the nightclub that was there, or was there a?
No, it was a tenant. He never ran it. He leased it to someone, and he wanted me to work with them to try to show them the proper way, far as running the bar. But by the time I came in, it was too late. It was
What kind of provisions did the lease have as far as operation of the nightclub? Were there powers in the lease to take action against the tenant if, if there were the complaints of the type that the committee has talked about?
I don't think they had that written into the lease far as,
Try to?
well, I don't know, did you try to? Yeah, he tried by getting them to conform with the liquor board suggestions, and I went in to try to, work with them, the security and other things, and cleaning up. But at that time, when I came in, it was already in the grinding wheel, and it was almost ready to close. So I got there just a little bit too late.
And what kind of background does Mr. Salazar have that would qualify him to competently operate a restaurant that wouldn't run afoul of the same problems that?
He runs a construction company now with like maybe 20 people. He has good skills there, and his wife, she, has the skills to run a restaurant and manage it.
We used to have a restaurant, 246 South Broadway. That used to be my wife running for 7. Yeah, 246 South Broadway. That used to be my restaurant. My wife, she running for 7 years, and we just sold it like a year ago. So that's why we just try to open a restaurant. That way she can work at it.
And what were your hours at the restaurant?
The Santa Ana restaurant was from 10 to 10. 7 days a week. That's what it was. In Santa Ana. So we just try. I mean, we're not gonna work in like 12, 1 o'clock in the morning. I mean, it's just gonna be a restaurant.
Do you have alcohol sales there?
I don't think it. I mean, I just want to do a restaurant for right now, because I just want to.
No, I mean, you said that your wife operated the last restaurant for 7 years.
Oh yeah. That we have.
Do you have alcohol sales?
Yeah, just beer and wine. That's it. But we do have a liquor license. It's in my name still.
Oh, you do have a liquor license.
Yes.
It's in your name.
Yeah.
It didn't transfer with the other restaurant?
Not yet. But it's gonna solve it with the new owner. My wife, she's still helping them to, out a little bit.
Okay.
Just to be clear, you don't intend to lease the property to another operator, or will you be an owner, operator of
I don't want to have no more problems, so I want to operate it myself. I just don't want to have a problem. That's it.
And have you considered any other potential use for that building other than a restaurant?
Well, I think if we do apartment, I can do apartment. But we're going to have the same problem. People are going to have a car. So where are they going to park it? They complain about parking spaces. We're going to have a problem also if we make apartments. Where are they going to park? I mean, either restaurant or apartment is going to have a problem with the parking space. But we can work it out. See, we
Seems
can
like you wouldn't have any opposition if you were proposing
Well,
residential dwelling.
yeah.
Oh, well, maybe the council president's office would help you with that. Or Councilman Kraft and Councilman Stokes. All right, anything for? All right, thank you.
Thank you.
And that's the 3 o'clock bucket. Yeah. I'm sorry, I thought that you wanted to be part of the record.
Yeah. I hear you.
There you go, sir.
You're welcome.
We off the record?
Yes. Actually, let's start with Clinton Street.
Got a question mark next to that?
Yeah, we sort of handed them some what they're taking.
For, sure. You know, hey, you can't save people from themselves. So, okay, fine. We have to evaluate the merits of either side. Okay. I was trying to give them either side a way to live with the result. Whatever. All right, Clinton Street.
Quite a bizarre.
I hear the concern of the planning department, and you look at the map, and you look at the, both from the aerial and the subdivision plat. It's a lot of development going into a small area, and the access to the Muse or whatever it is by way of an alley that's 13.5 feet wide. Which, Martin, does that create public safety issues? I mean, I don't know, how do you, if a house catches on fire back there, how do you access it?
Obviously cannot get back there because they demand a 16-foot wide
Yeah.
way, whatever it might be. And to create a 16-foot wide way, you'd have to take down a piece of the building.
Yeah.
The department was also concerned that, the way this was explained to me, because this Muse, as they called it, was not going to be exclusively for pedestrian use, it would not satisfy the requirement of the zoning code definition for what has to be the alternative to frontage on a public way. Those 3 units in the back will not front on a public way.
Yes.
And this particular slice of the property that they want to use to allow these things to front is not going to meet that definition. Because it's not pedestrian frontage, it's a vehicular frontage. Now, that sounds ironic, given the fact that there's, concern about access to the parking provided. But that's the way the zoning code is written. And it's in a sense, it's a zoning technicality, but it's a very important one in the eyes of the department. I think the other thing that struck the department most was it is possible to use this property, as even Mr. Barry suggested, up to 17 dwelling units could be put on this property by right in the OR zoning that's on it now. Not that we want 17 dwelling units, but the point is, this particular proposal is not this or bust for this particular development. And it's the department's position that this particular subdivision proposal would not be approved, would not be recommended for approval certainly, by the planning department to its planning commission. Now, as Mr. Berry said, on one other occasion, we mentioned the property on Ford Avenue, the planning commission did not agree with the planning department's staff recommendation, and they voted to approve something. But the difference there was, as I recollect, the way that was being created led more directly to a wider public way which would allow access. And that was the thing that the planning commission saw as critical. That what that particular 30-foot slice led to was not a 13.5-foot wide alley, but something that was at least 16 feet wide. So they saw it in fire and safety context. Now, yes, they're not the building code people, but nonetheless, that was part of their deliberation. This particular property, because of the peculiars of the property, doesn't allow the developer to offer that option, unless he slices off the end of the building. And we're not asking him to do that. Frankly, we don't want him to do that. We'd like him to try to save that particular part of the building. Because ironically, the historic preservation planners have pointed out that the whole wall that runs along from Clinton Street along that 13-foot-6 alley is in fact of historic significance. If it could be saved, it should be saved, is the position of the historic preservation planners. Obviously, the developer in this case would seek to remove a portion of that wall, and because he intends to do that, in order to accomplish this subdivision, he's willing to give up the possibility of having a historic tax credit for what he wants to do. That's a business decision. You know, the department has no authority to enforce preservation of any particular wall of this building or any part of this building, because it's not in a local historic district. It's in a National Register historic district. So the property owner can get the tax credits if he wants them, or he can leave them on the table. It's his business.
Mr. Chair, can I mention one thing? It's being not entirely accurate. Just regarding the private right-of-way touching another public right-of-way, we actually changed our plan. You guys can see that it sort of dog legs and touches Clinton Street, not just, which is a technical requirement of the subdivision regulations, which we didn't have in the original submission, spent a fair amount of time redoing. Granted, it's a technical piece to it, but it's important that it gives us, we believe, the leeway for the planning commission to approve it. Where if it didn't touch Clinton Street, Mr. French would be correct that they wouldn't actually be able to approve it. The fact that it does, it gives us the basis to be approved by the planning commission. And it's a 40-foot right-of-way we're providing, which is allowable for vehicular access. The zoning code requires 50 feet, we're providing 40. Planning commission is allowed to waive 10 feet down to 40 feet, which is exactly what we did in the Ford and Race case. We spent a fair amount of time making sure that this is a plan that's able to be approved by the planning commission. Whether or not planning department supports it or not, that's one thing. They didn't support the last one, that was approved by the planning commission. So, and I don't disagree with anything else, but I just wanted to make that point that this is a plan that, whether planning supports it or not, is still able to be approved by the planning commission.
I think that our decision has to be made on the record that we've heard, and not
Not the additional comments.
Thank you.
What I was gonna say is that in some sense, I fault myself for it. But in looking at the plan, I mean, it really does create safety. I mean, when we had a similar one of these a couple weeks ago, I think, metalworking artist studio or whatever, but that wasn't going to be residential. That's right, and that was non-residential, it was all just. But here, you've got houses that are going to be the houses on the front of the lot, so on the Clinton Street side, are going to be 51 feet deep. Then you're going to have another 40 feet. So that's going to be 90 feet from the street. You're not going to be able to reach that with a fire. If you look at it from the other side, on Highland Avenue, the houses there, according to the tax map, are 63 feet long. So you're talking about from the Clinton Street side, it's 90 feet you have to go before you get to the houses. On the other side, it's 60. I don't know that you can effectively you certainly can't get equipment back there. I don't think that you can get a hose back there. And it might be 63 feet from Highland back to the edge of the house. It's there, but if you're talking about the interior corner, that's just unreachable. And we've got a variance request in front of us. And one of the things that we have to consider is public safety.
increase the danger of fire.
Yeah. And right now, it's not residential, but talking about it becoming residential. And I think that the prior use, I'm gonna imagine it was grandfathered in under the zoning code. There's some testimony that's been there for, I guess, with the Boys and Girls Club or something like that. So it likely it's been there since before the zoning code. But I'm concerned that putting houses back there in a situation where it's unreachable for fire equipment is a hazard.
Well, I think the applicant met the standard for uniqueness. I think the applicant met the standard for practical difficulty. I think they met the standards for, it's not exclusively to, on a desire to increase the value of the income potential, because they could build 17 units there.
Yes.
I do share your concern about the width of that alley, though.
On the hardship issue, I wasn't quite persuaded on that because of the conceded ability to put 17 multifamily residences there. You're talking about, I don't see the hardship between, well, I've got two equally possible marketable uses of the property. But I want to do this one sort of because. So I thought that sort of eroded the hardship. There was the argument as to the issue that's created because of the width of the right-of-way requirement, and if it was smaller, then they could move the building up a little bit, and that could create a hardship. It's a little bit closer, I guess. I was a little bit more impressed by that. But, I mean, overall, what my concern has been is really more from a safety standpoint. As I said, I think I kind of fault myself because we didn't really ask any questions as to what considerations had been made of that aspect of the project.
If we wanted to ask those questions, we can bring it back.
We could. Although I don't see how you address it anyway. I mean, I'm guessing what it's going to be is that new construction, so you're building in fire systems and you're building in sprinklers and things like that. I know that has usefulness in controlling spread of fires and delaying it, but I mean, here's a situation, but that's presuming a situation where a house is accessible for the fire department, so you've got, it's fire suppression system, so it's going to keep it under control until equipment can arrive and they can put it out. Here, you're not. I mean, I'd like to get some kind of feedback maybe from the fire department as to.
There is a 20-foot alley on the other side.
There is a 20-foot alley, but it's only accessible by 10-foot alley.
Yeah, I was going to say, how do you get to that off of Marshall Court? It widens up to 22 feet.
Yeah, but it's 9 feet at the entrance from the road. So,
I understand, but
I saw those as well. You've got these large interior right-of-ways, but as far as getting out to the street, you've only got 9 feet, 10 feet, and 13 and a half.
This is going to be before us again, too.
sure the fire department could get there if they had to. But I can't speak for that.
I mean, I'm guessing you have to pull the truck up and you likely have to link hoses.
Yeah, I'm no expert on fire.
But yeah, you might have stumbled on a solution to that.
Holds up area.
Yeah.
Do you want a written response to your question from the?
Yeah. And yeah.
So a memorandum from the applicant addressing the safety, the fire.
Yeah.
Okay, holds up. Is that the only issue? Written memo addressing
Well, it's the only issue that's remediable by further information.
fires. Okay.
All right.
So we essentially tabled that?
Yes.
And I guess we'll email you or give you the memorandum.
When we convene again,
Okay.
if they can have it for us ahead of the next meeting, and that way we can all.
Yeah, have it distributed to everybody.
Yeah.
Okay.
All right. brings us now to Bank Street. I see issues with both. Well, that is with both sides. We had a case on our, where is that? No, I guess it wasn't consent. But we also have to consider Decatur Street, which is a tavern with a use that had been discontinued for some time as well. Now, certainly there's not the intensity of opposition, but that doesn't always turn the day.
Yeah, but to me on Decatur Street, there's different facts.
That's-
The facts
yes.
are that there was a legal action trying
Right.
to get
Yeah.
possession.
Although that I'm a little bit, like, if you look at the dates, there are some gaps that are there,
there's
and I
some gaps,
understand that
yeah.
there's personal circumstances. But it's more so that the issue of abandonment and extension is presented in both cases. And what my concern is what it is with all of these requests is, okay, well, you know, what's been going on with the property, what will go on with the property while it sits there. And typically, we have the ability to control those, you know, as far as the proposed use that's to be made. Here, we don't have that. Although I guess, isn't it, David, is a continuance treated as a conditional use? If you extend it,
I'm sorry, I misunderstood.
for an extension,
Uh-huh.
it's treated as a conditional use?
To extend
And-
in time,
yeah.
non-conforming.
Yeah.
Um,
Well, that sort of narrows it even more. I was gonna say that maybe we could put some on ourselves without it being presented as part of an agreement, but no, that's taken away.
The extension is,
Well, to go beyond the initial 12 months, my reading of the statute, there's no standards whatsoever. It's
That's correct.
Wholly
Right.
discretionary on our
Yes,
part.
yes.
And I
And
guess I would make the argument, if it's wholly discretionary on our part, we can condition it.
one of the issues is if they remove the equipment
Mhm.
and
Yeah.
vacate the building, then that's abandoned.
And then, yes.
Uh,
And there's
which
no-
you didn't do in the case of Decatur Street. Everything was still in place.
Correct.
Mhm.
I don't know about.
Well, yeah, here there's no evidence of that. And so, I mean, it really just gets down, and that's what I was talking about, is that it really kind of gets down to, all right, well, you're on these two opposite poles.
In the Bank Street property, they were actually changing the use from a tavern to a restaurant. So it would require renovation of the interior.
Well, I think he said that what it was gonna do is gonna remove the bar area to open it up.
Put in
Yeah.
the kitchen
Mhm.
and.
All right. So what's our thought? Well, yeah, you're Mr. Renovation.
Reframe that question.
That's good. I like it.
You're development conscious and eye towards renovation, reuse of properties. working within community associations, well, working with communities. What's your thought?
Well, assuming that there is, consensus isn't the right word, but it's assuming that there's enough of a voice, I tend to side with the communities.
I mean, with regard to this one.
Oh, I'm sorry, I thought you were asking me in general.
Oh, no, as to
Well,
Bank
ask me the
Street,
specific
yes.
question, 'cause
So
you covered
what are
the
your
injury.
thoughts as to Bank Street?
He has a right. I mean, he has a right to do what he wants. I'm not sure if I were him, I'm not sure I'd want to open a restaurant in a place where I particularly wasn't wanted. And their opposition is certainly warranted, given his track record. Although he wasn't running the business, he was the landlord. So that didn't necessarily mean he's going to be a poor business owner. It just means he was waited too long to step into a really messy situation before. I could only speculate that that was because he didn't want to lose his rent, because he needed the money to pay his mortgage payments. But you know, I'm a little put off that either side was willing to try to step out today, although the opposition did make their voice known that they had, I believe them when they say they've made legitimate efforts in the past and to no avail.
I was disappointed that they were so angry with each other that they weren't willing to talk again.
Yeah.
Because it probably would have resolved
You know, they answered my question as to whether it
in
was
a way that could have pleased them.
right.
Yes.
I mean, you know, I was specific in the question, is it about the restaurant or is it about something else? While they voiced that it was about the restaurant, I think it's as much about the individual.
He hasn't been a good neighbor.
Right.
But we can
So
put
regardless of what
restrictions in
business,
place
whether it
that
was
will-
residential or not, I don't think it's about the vacant building so much as it is just that individual. And, I would share the concern of being a citizen, but I'm inclined to side with the neighbors in this one. Although I very much acknowledge that it's his right to do what he wants with the building. But at some point, we have to give consideration when there's such a groundswell of community support. The fact that the council members were there doesn't really affect me so much, is because they generally always say, we're going to support what the neighbors are saying in this situation. I'll save my sarcasm for another day, but
Marty?
I'm a little troubled by the language that suggests that if you remove structures, machinery, and equipment, or alter the premise, that indicates a change in use, then you no longer have a right to continue that non-conforming use. I'm struggling with that a bit. That seems to suggest changing from a tavern to a restaurant. It seems to suggest that.
Well, as I understand that part, that's
Right.
looking at the
abandonment.
the period of discontinuance, if during that
Yes.
it's been removed.
Right.
And it sits as is.
Yeah, but if it sits as is, and I think that I didn't hear any testimony that there were any changes or that there were the removal of any fixtures and the like. So,
Well, I'm reading that this to interpret that he's got to make changes in order to convert it to a restaurant. Right?
he doesn't even have a kitchen at this point.
I know, right.
So he has to.
Sure.
Right.
I think that that if there are going to be subsequent alterations, I don't think that figures into the abandonment question. I think that abandonment and discontinuance looks at during the period it's been discontinued, if you have removed.
Actual abandonment is evidenced by the removal.
So I have a question. So you mentioned to them that the vote was up or down.
Well, look at 15303.
It's of a variance. Yeah. That's imposition of conditions on a variance.
Yeah. No,
But it's not asking for a variance.
Yeah, I know that, but it gives us
That's-
some,
Yeah, and I think that, I think that you're right that that because the code presents it as is purely discretionary, I infer into that we've got the ability to make conditions on it because we've got no obligation to grant it. And there's no standard to evaluate it by. The thing that that I always recall in these situations, I remember there was that case in is it Remington. There was an appeal of a case where we had put conditions on a use, and the owner had appealed the imposition of conditions, and we'd gotten reversed because the circuit court said that we didn't have the ability to place conditions on it because it wasn't a conditional use request.
It was a non-conforming
okay.
use, and we put conditions on it, and the court reversed it, saying we could not put conditions on it.
All right. I
That
forgot
was
about
the
that.
corner of 27th Street.
Yes.
Mm-hmm.
Jeff, let me clarify something, because you asked me, you caught me in the middle of a daydream, I apologize. But you asked me to put on my developer's hat. And within the context that I work as a developer, and although you can call it sort of a humanitarian type of organization, I personally would, if I'm walking in his shoes, I personally would not pursue it in the face of that much opposition.
But yeah, I mean, I can see that the thought is that, you know, if you're gonna put a restaurant in somewhere where you might have.
But you asked me from my
Yes,
perspective,
yes.
and that's my personal perspective. But that being said, he still has a right to do it.
Okay.
Yeah, if it's just a simple, is this an up or down, decision tree? Then, I think we have discretion as a board to extend. And, be inclined to extend.
Yeah. And just what I'm not clear of is just to how much, even reduce it to a matter of a percentage. The code says this, and that's weighted 50% of the decision, community support or non-support is this, that's 20% of the decision.
Well, oddly enough, the presence or absence of community support isn't a factor. Well, at least as far as to conditional uses and variances, as to things that are purely discretionary, certainly it's something that we can consider.
Which in this case it is.
Sure. Just as it's always the consideration of an individual's property right. So we have to juggle both. I would still want to impose, if there was going to be granting this, I would still want to impose conditions on it. Because I'm just simply concerned about the operation. And yes, and enforcement isn't, while we always say that we're not in the enforcement business, but if there are requirements that are part of his ability to operate, that's different.
Bob just pointed out to me that, restaurants, he's changing from tavern to restaurant. Restaurants are conditional uses in the B1 district. So, if one were to consider allowing as a change in non-conforming use from a tavern to a restaurant,
Change to a conditional use, you could attach conditions to that.
conditions
Okay.
on the use as a restaurant. Unfortunately, he didn't present any request or plan for.
Well, I don't know
And
about
as
that.
it's presented, that still doesn't.
He
that
answered
still
a
doesn't
number of
address the
questions. Number one, he
concerns.
said restaurant only. Number two, he said no alcohol. And number three, he said his other restaurants operated 10 to 10, and I think all of those would be reasonable
Yes.
to impose here.
Well, he said no alcohol right now.
Well.
He can come back.
Right.
Yeah.
But that still doesn't address opposition's concerns of not wanting a restaurant, period.
Understood. I'd also note that if someone else, say he sold this tomorrow, someone else came in and wanted to operate a tavern there, it's a current use is tavern with live entertainment and dancing. Now, I think that another person would probably be in the situation, could possibly be in the situation of having to come back to the board with an application to continue to use and try to get acknowledgement of that use. Conversion to a restaurant use, obviously, in the residential district, it doesn't allow that live entertainment portion.
Right.
So you're not dealing with an establishment that would be able to play music. Now, there were issues with, I guess previously there were issues with, I guess what was going on outside of the venue, but maybe that was just simply related to the operation of the nightclub and consumption of alcohol. So if there's not ability to, so if you take the alcohol off the table, then, yeah, plus would be out. All right. Were there any others?
I'm okay.
Yeah, I'm from Decatur as well. Okay, you ready? Oh, that's right. Okay. All right, 2014-159, 1314 William Street was by consent. 2014-225, 108 North Utah Street was by consent. 2014-226, 106 North Utah Street was by consent. 2014-258, 1609 Bank Street. I am a yes as to the proposed restaurant use with conditions imposed as to hours, 10 being 10 to 10, no alcohol sales. The operation of the restaurant, as far as number of tables and chairs, is per the, oh, that's right, we gave him back the drawing. Well, we'll need to get a copy of that. But it's per the proposed drawing. And what was the last one? We had hours, alcohol sales.
Live entertainment, was it?
Well,
Well, they
have
can't.
that, yeah. Maybe we want to say restaurant use only.
Only.
Yeah.
Well, they can't, with no alcohol sales, they can't.
No, right.
But I thought you said there were three things.
I had restaurant only, no alcohol, 10 to 10.
Okay. All right.
I'm a yes on those conditions.
Yes, with those conditions.
I'm gonna be a no.
Heavy is the head that wears the crown, Mr. King.
I question whether we can put conditions on this. How do we get to being able to put conditions on this?
What David was pointing out is that because a restaurant would be a conditional use in the district, so that's how, because they'd be operating as, their use would be as a conditional use.
I agree with conditions.
Okay. 2014-260, 3120 Hudson Street was by consent. 2014-261, 1033 Light Street was by consent.
You skipped Decatur.
Oh, I did? 2014-259, 1401 Decatur Street. I'm a yes.
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 Agree.
2014-263, 511 through 19 South Clinton Street. We are holding pending submission from the applicant. Can we also get something from the fire department as well? It doesn't have to be something formal. 2014-265, 3459 Chestnut Avenue. I am a yes, with the agreement between the parties that the proposed garage will be 12 feet 6 inches by 20 feet.
Yes.
2014-266, 1215 East Ford Avenue was by consent with conditions stated by the planning department. 2014-267, 508 South Milton Avenue was by consent. 2014-268, 812 Stiles Street was by consent. 2014-269, 1104 Bayless Street was by consent. 2014-270, 416 through 18 East 30th Street was by consent with agreement between the applicant and the community association. 2014-271, 2002 Gulf Street was by consent. 2014-272, 4017 Liberty Heights Avenue was by consent with conditions stated by the planning department. All right, we will take a, call it 5-minute break.
Yep, sounds good. Yeah.
Yes, it is.
Those of you here for the
Yeah, the bonnie boat was one as we sail into the mystic. Oh, I can now hear the sailors cry, smell the sea and feel the sky. Let your soul and spirit fly into the mystic. And where that foghorn blows, I will be coming home. Yeah, when the foghorn blows, I wanna hear it. I don't have to fear it, and I wanna rock your gypsy soul, just like way back in the days of old. Yeah, magnificently we will fold into the mystic. When that foghorn blows, you know I will be coming home. Yeah, when that foghorn whistle blows, I gotta hear it. I don't have to fear it, and I wanna rock your gypsy soul, just like way back in the days of old. And together we will fold into the mystic. Come on, girl. Too late to stop now.
When I had you to myself, I didn't want you around. Those pretty faces always made you stand out in the crowd. But someone picked you from the bunch. One glance was all it took. Now it's much too late for me to take a second look. Oh, oh, baby, give me one more chance. Won't you please let me back in your heart? Oh, darling, I was blind to let you go. Now that I
Yeah, no, we'll do it as consent. All right. Good evening and welcome to the July 29th convening of the Baltimore City Board of Municipal and Zoning Appeals. A couple of housekeeping matters before we get underway. If you have a cell phone, a pager, anything that makes any kind of audible electronic noise, we ask that at a minimum you turn that to a vibrate-only position. Additionally, to the extent that you need to have a conversation with someone in the gallery, we ask that you please take that conversation out the double doors to your rear. And the reason for both of those is the same. There are microphones arrayed around us up here, and those microphones are all very sensitive. They're for the purpose not only of amplification, but also for the purpose of recording these proceedings. And conversations in the gallery, cell phones ringing and the like, disrupt the recording of these proceedings as well as the general conduct of the proceedings. We will be voting at the end of the day. You're certainly more than welcome to stick around for a civics lesson if you so choose, but if you'd like to get home this evening at a decent hour, it's understandable, and you can call in at the zoning board office and find out in the morning how we ruled. Take out pen and paper. I can give you the number for the zoning board office. That number is 410-396-4301. Again, 410-396-4301. You will, however, need to wait until you receive the formal written outcome of your case that should be forthcoming in about 3 to 4 weeks. If you haven't already done so, if you're here in opposition to any case today, we ask that you please sign in on our sign-in sheet. I don't think we have anyone yet, right? Okay. The reason that we have a signing sheet is so that we know generally which cases have opposition, but also so that we know who needs to receive those aforementioned notices I just referred to. The procedure for when your case is called is that you'll come up, the appellant will stand to my left or your right, the opposition, if any, will stand to my right, your left, we'll get you sworn in. The appellant will be given the opportunity to present what it is we're all here to hear about. What is their proposed use for the property, what issues are presented by that proposal, respond to any questions raised by the board. Once they're done with their presentation, we'll turn to the opposition, we'll be given an opportunity to present their side of things, then we'll return back to the appellant to respond to any points brought up by the opposition. We won't, and also be given the opportunity to give a closing statement. We won't be going back and forth, unnecessarily delaying things. We will be calling the cases in the order in which they appear on our docket after we address a couple of preliminary matters. First, we may have a issue with posting as to one of the properties. 2014-275, 1722 Prestman Street, Bong Kim.
Should we make this a separate case?
Hmm?
Should we make this an actual track for the case?
We're just handling preliminary matters. We need to inquire about posting. Good evening, gentlemen. Who's Mr. Kim?
Yes.
Okay. When you, after you submitted your application for the appeal, did you put up a sign on the property? Okay. And how long when did you put the sign up?
July 8th? Yeah.
Okay. So July 8th?
Yeah.
Okay, so that would be 21 days.
Who's Mr. Kim?
Yeah.
Mr. Kim.
And what's your name?
Oh, mine is my brother. Yeah.
I need your name.
Name.
Don Kim.
How you spell that?
D-O-N-G.
And yeah, if only one of you can speak at a time, gentlemen, so one person speak. So you put the sign up on July 7th or 8th, correct? Okay, and it stayed up the whole time? Sometimes signs can fall down. People will like come by and they'll rip them down. Do you have any issues with anyone pulling them down? No? Okay, have a seat. We'll call you in turn. Thank you very much. All right. First case we're going to address is our our lone case on the consent agenda. Consent cases are cases where the zoning board staff has reviewed these files and determined that we have sufficient information to approve this appeal. The one case on our consent agenda is 2014-274, 803 South Milton Avenue. Michael Coster. All right, Mr. Coster, you've previously been sworn. We have this as an application to construct a second floor rear addition with rooftop deck access from the side stairs. Is that correct?
Correct.
All right. And Mr. French, anything from the planning department?
Planning department has no comment on this application.
Thank you. Mr. Coster, was there anything you'd like to add to supplement the record?
No, sir.
All right. The zoning board staff, having previously reviewed the application, determined there is sufficient information to approve your appeal.
Thank you very much.
Have a good evening.
All right, you too.
All right. The next case, now we're going to address the cases on the remainder of our docket. First case, actually there's two cases together, 2014-78, 1627 and 29 East Preston Street, AB Associates, care of Nate Predel. Call that together with 2014-79, 1631, 1633, and 1635 East Preston Street, also AB Associates, care of Nate Predel. Good evening, Mr. Predel.
Good evening.
And who do you have with you?
This is Martha Cross from TRF Development Partners, who are the developers of the property.
Afternoon, well, good evening, Ms. Cross. All right, Mr. Predel, we have as to, I think the descriptions are the same as to all of the properties, or as to each appeal. That is to consolidate the lots and construct a three-story semi-detached single-family dwelling with first floor rear deck and rooftop deck access from a stair penthouse. Is that correct?
That's correct.
Okay, you've been sworn, Mr. Predel, but Ms. Cross, if you can raise your hand and be sworn.
Do you swear or affirm the testimony of truth that you give this hearing will be the truth, the whole truth, and nothing but the truth?
I will.
All right, do we have staff reports?
Planning Department is recommending approval of both of these applications. These applications were revised from their original form back in April of 2014, and the department is satisfied that the changes that were made, in fact, have substantially improved the application and, in fact, will be a significant contribution to the benefit of that neighborhood. Thank you.
Thank you, Mr. French. Okay, Mr. Predel, why don't you tell me what's been proposed here, and I guess you can start with 78 and then go to
Sure.
79.
Before I do begin, I think these were in your file, as Mr. Henry didn't read them. I had two letters of support for, I guess, for each property, co-signed by both the Oliver Community Association and the Oliver Economic Development Corporation. I think they should already be in your file, but. We don't. Okay, you don't have them. In any case, there they are. So a brief description, I think it serves to describe them both together, because they really do work together. What we have, the existing conditions are 5 vacant parcels on the 1600 block of East Preston Street that we're proposing to consolidate. And the consolidation will be the western 2 parcels, 1627 and 1629, will be consolidated in a single 3-story, single-family attached dwelling will be built. On the eastern 3 parcels, 1631, 33, and 35, another 3-story, single-family attached dwelling will be built. I think your guys' staff report has them as a semi-detached dwelling, which changes the degree of variance. Well, technically, they are semi-detached dwellings because there's a small sort of breezeway on the western portion. In fact, they act as the single-family attached dwellings, in character with the neighborhood. We're seeking several variances for the property, one for minimum lot area for both lots. And again, if these were characterized as single-family attached dwellings, we wouldn't need minimum lot area variances. There's minimum of 1,100 square feet for an attached dwelling, 2,000 square feet for the semi-detached. So in any case, it's within the board's authority to approve. We're also asking for a variance for height and maximum lot coverage. We're proposing to cover, on both cases, about 45% of the lot. And in a semi-detached dwelling, the maximum lot coverage is 40%. If they were attached, which again, with the rest of the neighborhood is, that's 60%. So generally, we're in character with the rest of the neighborhood. As far as the need for these variances, we have very unique properties. And if you want to look at a site plan, there's a diagonal alley running, and I have a block plat, if it helps for you guys. I think you should probably have that in your file, but in case you don't, you'll see an alley that runs diagonally to the rear of the properties, creating sort of a triangular lot with, each property is irregular in itself. They're all different lot sizes, different lot areas, which, inherently is in itself is unique. Without asking for these variances, we have both a practical difficulty and a hardship of building really anything, especially in relation to the rear lot lines and side lot lines. And again, with the lot coverage, I think the last lot, the rear lot line starts at only 1 feet from the beginning of the front lot line. So, and I'll let Martha Cross talk a little bit about what TRF does specifically in this neighborhood before I answer any questions.
TRF Development Partners is a nonprofit real estate group that's been working alongside Build in the Oliver neighborhood since 2008. To date, we've done approximately 80 units in the neighborhood, which are a mix of both new construction as well as rehab units, both for sale and rental units in the neighborhood. Generally, although it depends on our funding, our units are reserved for households making approximately 80% of area median income. Some of our units are reserved at the 50% level, and others go up to 120%. I don't know how much more.
I think that's good, unless you have any questions. Again, I'd like to reiterate that we've been working specifically TRF along with the Build Association with both the Oliver Community Association, the Oliver Economic Development Corporation, as well as the Baltimore City Planning Department. These designs have been approved by their Urban Design and Architectural Review Panel. I believe we have letters of recommending approval from the Planning Department. And again, as I said, we have absolutely unique properties. We required for these variances due to hardship and practical difficulty, and I'd open myself up to any questions.
The only thing I wanted to clarify was on the drawing submitted to the board, it shows
Yeah, Mr. Tanner, maybe this is in.
you can look at what it.
Yeah, these are the old, I said, when this file was revised, and maybe that's the reason you don't have a community association, if some of these community association letters, if some of the plans were maybe misplaced in a wrong file, because we updated it with a different set of plans that showed.
5 lots involved.
Correct, those are the old plans, and these were updated when the new plans were filed, or when the new appeal was scheduled, maybe a month and a half ago.
The consolidation of lot.
Yeah, correct. Those are not the current plans that we're discussing today.
One property will be consolidation of lot 51 and 52 together. And then the other will be 53, 54, and 55.
Correct.
And in these drawings, it was reversed.
Yep, those were the original plans submitted back several months ago that were changed. And it was switched around, so now, yeah, you're right, it's 51 and 52, and.
I just want to make sure I have it right.
Yeah, and again, these were submitted to the zoning board a while ago. I'll leave this package.
Okay.
I do have them also.
Yeah, okay. Yes, yep. They were amended. The reason, the original design that had associated with those was not accepted by the Urban Design Architectural Review Panel. TRF went back and sort of took another look at it, and they decided to switch where the lot line was, the consolidation line was going to be.
Okay, any other questions? Thank you.
Thank you.
All right, and 2014-275, 1722 Pressman Street, Bong Kim.
You have a sign that over 200 neighbors.
Just a moment. All right, you're Mr. Bong Kim?
Yes.
Okay, and I think we already established your name is Dong Kim?
Yeah.
Okay. And gentlemen, we have this as an application to add a carry-out shop to the existing first-floor delicatessen, is that correct?
Yes.
All right, if you can both raise your hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
And Mr. Mr. Barb, I've got it, that you're recusing yourself in this matter, is that correct?
Correct.
Okay. All right, do we have staff reports?
Thank you. Planning Department noted that this is a request concerning non-conforming uses in an R8 district. It is also property that is located in the Sandtown Winchester urban renewal area. And for that reason, there is an issue with the urban renewal plan, specifically that this property is listed in the appendix of that urban renewal plan as a non-conforming, or using the original terminology of the urban renewal plan, a non-complying land use. And at that time, it was listed as a tavern. However, it is still continued as a non-complying land use in the terminology of the urban renewal plan this day. And the plan has a specific prohibition against changing one non-complying land use to any other non-complying land use, or in zoning code terms, non-conforming land use to another non-conforming land use. Therefore, the issue that basically confronts the applicant is that in the board's consideration of this matter, the board may be able to approve, from a zoning code point of view, issuance of a use and occupancy permit for use of the property in the way requested by the applicant, but the planning department would be forced to place a block on that use and occupancy permit because of the terminology in the urban renewal plan. The department also notes that there is a requirement in the law that if there is a provision that is more restrictive than the zoning code and any other applicable law, which would include this urban renewal plan, which is an ordinance of the mayor and city council, that the more restrictive provision governs. And in this case, the more restrictive provision is that of the urban renewal plan. Therefore, the planning department recommends disapproval of the appeal because the proposed additional use of a hot food carryout shop is not a use permitted in a B1 district, and because the Sandtown Winchester urban renewal plan, which covers the area where this property is located, does not permit changes of non-conforming uses. Thank you.
Okay. I see that we had this case before as a delicatessen back in 1991. And I guess the tavern, what our record shows that the tavern use was sought to be reestablished in 1990. That was disapproved. And then it was used, then there was a conditional approval to operate as a delicatessen that came that following year in 91. How does the urban renewal ordinance figure into that?
Having not been there at that time,
I was going to say,
I can only
to a time
state
when I was just
that
out of high school.
Well, you don't have to go too far.
I can only state that the change apparently was approved without regard to this provision of the urban renewal plan. There may have been a determination at the time that it was better to have a delicatessen than to have a tavern. But nonetheless, the problem that is presented at the present time is that to change the delicatessen use to a carry-out food shop is something that the urban renewal plan will not permit in its present state. And we discussed this briefly before this hearing began. The ultimate solution in a situation like this is to have the urban renewal plan amended to delete this particular provision from the plan and to return the discretion to the board to allow a change of non-conforming use. However, until that happens, the department is obligated to abide by the provisions of the plan and would be unable to approve the use and occupancy permit issuance.
Okay. David, you look like you were going to say something.
I guess the question is, what are you changing? Why are you asking for this at this time?
Yeah, because
that area, we have right now grocery and deli business, but the business is not that good enough. So we try to make it some build up business. So we're looking for around there. Yeah, there's no any carry out around my store, and one carry out is 3 blocks down. But some little children, when they need a hamburger, then they have to cross 2 big streets. There's a lot of traffic. Anyway, that is a good reason. And the young people, they doesn't like walk down 3 blocks, 2 big street cross. So sometimes they feeling hungry about, they buying chips, cookies, candy. Okay, if we sell hot dog, hamburger, it's making good business, I think. That's why I try making carry out there. And also, and this time, people, we don't know how to do it, zoning changed it. So we apply, and after someone tell us, and get the sign from your neighborhood. So I asked the customers, they like it. Oh, yeah, you open, carry out, that's good. So we asked the customers, so because I'm on 216 persons, how many doesn't have 10 days? Do you have a grill installed in your existing business? It's already there?
No, it's not there. We're
not
going
there.
to install the grill.
So this is something you're trying to establish? So you haven't had a grill in the past? Oh, we never have this place, but me and my brother, we had carry-out business 11 years before.
So how long have you been here?
In America?
No,
No,
at this
this
location?
5 years almost.
5 years.
Yeah.
Okay. In 1991, when the board authorized the use of the first floor as a delicatessen, the use at that time said that, the application said that the delicatessen, if approved, will include display cases for meats, cheeses, sundry items, food, sandwich preparation areas, a grill, deep fryer, limited cooked foods such as hamburgers, french fries, etc. So I guess my question is, has this use as described in 91, has that been a continuous operation? And if so, then there's no reason for you to be here. But if, from what you're saying, that's not the case, I think is what you're saying. So my question was, how, has this operation been the same since 1991? And if not, what are you changing? I'm sorry, I don't. I'm just going by what the record shows from the previous appeal.
So it's not able to change.
So you don't have a carry-out business at this point, is that correct?
No, we have a cold deli sandwich shop and a grocery.
Which is fine, but the problem is the code does not allow carry-out in a non-conforming situation. So unless it's been there legally established since 91, it's hard to
get approval to put it in there. Now, you have a hurdle because carryout's not permitted as a non-conforming use, and the urban renewal plan prohibits it, so it's a big hurdle to overcome.
You say you've been in the business for how long?
11 years.
And what business establishment was there prior to you?
When I came to America first time, 1983, but 1984 I started career. 11 years we had
No, no,
that.
in that location, what was there prior to you getting to that location?
Oh, the same like a grocery and deli.
And they were conducting the same kind of operation that you're conducting?
Yes.
Okay, I think you see the situation that we're in at this point, that the code only allows the board to recognize or approve certain uses, and it doesn't give the board authority to approve other uses. And this is unfortunately one of those situations where the code doesn't allow the board to approve carryout in this location for a couple of reasons. And as explained by the planning department, even if we did do that somehow, they would still deny a permit on the basis that it's prohibited by the urban renewal ordinance, which the property is subject to. Now, I think that Mr. French suggested that there is a way to address that by deleting the carryout prohibition from the urban renewal ordinance. And I guess they couldn't have the property removed, correct?
No, it would actually take a change of language in the urban ordinance.
Yeah.
And this is something that has been done in a couple of urban renewal plans so far, but a number of others like this one have not, just haven't come in.
Okay. So I think that that's sort of the only route forward as far as what you're looking to do. You'd said that the only carryout that's around there is located some distance away from you, and I think that that might be the reason for that might be because of the same issue that you're hearing about here, that it's not something that's approvable in your area.
Okay, then what thing can I ask about? One thing. Okay, 1991, there wasn't this proof. So that time, and I had a career in 1984 start. That when I started, it was very easier. Just we make a license, then we can make it career open. But after changed a lot of rules. So how to make it carry out condition, what kind of fire system we have to have, and what we have to do. Right now we have to food manager course. We have to be there and how to making safety food, everything we're learning. So we know. In 1991 when they did this, right then. That time condition is, I don't know how it was, but right now, we knew what we had to do. Only zoning making, no carry-out business. Anyway, there's business place right now. So when we try and open carry-out there, we making what city want, how to making fire system, how to making alarm system, everything, how to making safety. We're trying to make it perfect.
then I think no problem about it. And when I was thinking open carryout, okay, there's not much problem. Okay, we may put it in all the equipment and change the license, then I think I can make it. But I try making carryout. First, we needed to change the zoning. So what is the zoning? So we came down here. Okay, they asked, tell about what we had to do. So we didn't put on the sign. Everything. I don't know.
Well,
That's
we find
too-
out it's not able to, change the carryout in this place.
I'll say that the situation that you're in isn't one that is uncommon. I think that it happens with, certainly where we see it, probably at least once every time we convene, that there are folks who are in your situation where they have an idea that they want to pursue, and then they find out late in the process that that their plan is something that's not able to be approved. Actually, I would say that in some of this, given some of the situations that we've seen, it's fortunate, you're more fortunate than some others have been, where they've actually only found that out after the expenditure of a lot of money in making improvements or building purchase or something like that. What the zoning code does and doesn't permit can be a surprise to property or business owner, and it. The only thing that we can say is that it's important at the beginning of the process to start at the stage where you're looking at, well, what is it that I want to do, and what is it that's possible under the law, and it takes some time to understand that or to find out those answers, and it can be time-consuming and frustrating. I think that there has been kind of an evolution of concerns regarding different kinds of uses. It sounds like the urban renewal ordinance prohibition against changes in non-conforming use here has been one that has been around for a while. But the kinds of things you're talking about, sort of where some time ago it was easier to pursue something, and then later on it's more challenging to do it. That's not uncommon either. I think that that's just a reflection of as communities get more engaged and they start to be more forceful, or they start discussing more of the kinds of things that they do or don't want to see in their communities. This, sometimes the effect is that uses that may not be problem uses, such as, it doesn't sound like there's much difficulty or that's caused by your business, but they still encounter the inability to pursue those plans because of concerns with whether there were other operators of different uses in that same area the community has become concerned about. But the spillover effect is that it leaves folks like yourself unable to pursue their plans, even though they may not have an issue with your business or the way it's been operated. I can't really say anything other than that the board only has certain authority, and this is one of those areas where what you're asking, the board doesn't have the authority to give you. It can be, as I said, unfortunate and frustrating finding that out late in the process, but unfortunately, that's the situation that we're in.
So this place, this area is not being changed since 1991.
Well, I think that the urban renewal ordinance has been in effect sometime longer than that. Yeah.
78.
When I was referring to 1991, that was the approval to operate the delicatessen.
So nobody trying to change the
Zoning.
So what we can do is do the postponing.
Yes, you can postpone your case and then.
Contact with the councilman. It doesn't matter what's the community and the neighbor, you know.
Well, it's actually good that you've got that kind of support because council people, they represent groups of people. So if you've got some support for what it is you want to pursue and you say, well, we've gone out and we've gotten these different folks to support what we want to see here, then that'll help you, or can help you gain the council person's support.
Yeah, but is there any other case, in past the, permit, you,
Change the zoning.
change the zoning, using the help from the, councilman?
There are two different things. There's changing the ordinance for renewal, and there's changing the zoning. They're both actions that require the mayor and city council to approve something. They're two completely different things. No, there's been no recommendation to change the zoning in that area where you have your shop that I'm aware of recently.
So how we gonna postpone?
You asked?
You ask, and I will grant your request.
Postpone, decision.
Okay. 2014-275, 1722 Pressman Street is postponed. So your next step is you'll want to try to reach out to the councilperson's office. They typically have a community liaison that they work with, and they'll work with you through the process after that. Okay?
Thank you.
All right. Good luck to you.
Thank you.
Thank you.
Thank you.
And we're off the record. Okay. Any cases that we want to talk about? Since we only have one. Okay. 2014-78, 1627, and 1629 East Preston Street. 2014-79, 1631, 33, and 35 Preston Street. I'm a yes. Yes. 2014-274, 803 South Milton Avenue was by consent. 2014-275, 1722 Pressman Street was postponed. Okay, and there it is. Okay.
So cool and let me know the lowdown how you feel about things.